Can we start? Yeah. Good afternoon, distinguished speakers, esteemed guests, and respected professors, esteemed participants. On behalf of Organizing Committee, Department of Studies in Law, University of Mysore, I extend a warm welcome to all of you for this inaugural session of this international webinar on the legal framework, Synergizing Sustainable Development Goal and Intellectual Property. It is a pleasure to have an esteemed gathering from various universities, and we are truly honored by your participation in this significant event. Before we begin this program, allow me to give a brief overview of the program. This webinar aims to explore the intricate relationship between intellectual property and sustainable development goals, to emphasize the legal frameworks that are vital for harmonizing both these crucial areas. At the heart of today's discussion, intellectual property, we discuss the crucial drivers of innovation and creativity. It is no secret that the development of new technologies, products, and services, especially those addresses climate change, health, life-saving medicines, and education, is critically crucial to achieve the sustainable development goal. IPR provides necessity incentive for the creators and inventors of the IP and IP rights. Their ideas are commercialized for the solution and attract investment. So the inventors and the creators, they fosters research, development, which accelerate emergence of sustainable technologies and development, which are similarly aligned with the sustainable development goal. The synergy between intellectual property and sustainable development cannot be overstated, but there is an equally and critically component that binds these concepts together. Environment, social, and governance. These are the three concepts which can connect intellectual property and sustainable development. ESG, what I have explained, has emerged as a powerful tool to assist and guide the corporate governance and corporate behaviors, ensure that the business practices are not only economically profitable, but it should be socially responsible and environmentally sustainable. In this regard, the companies that integrate these three components, ESG, consideration into their business strategies, are often seen as more resilient, sustainable, and attractive to investors. In this turn, these business companies which integrate SDG to their way of life also contribute to overall of the achievement of the sustainable development goal. The challenge would be, can the legal framework governing IP evolve to better reflect and support ESG consideration? How do we balance the exclusivity of IP with the need for the open access to the critical innovation such as renewable energy technologies, life-saving medicines, and sustainable agricultural practices? Further, how we can create IP framework that promotes sustainability while protecting public interest? How can IPR can be used to foster inclusive, responsible innovation and not just benefit a few, but whole humanities? These are some key issues we will explore over the course of this webinar. To further discuss, here is the role of circular economy, that it is a principle of economic which become very crucial. A circular economy which is focusing on the reducing waste, reusing materials, and recycling resources, that is aligned perfectly with the both sustainable development goals and IPR. How can we innovate within the circular model while also ensuring that business are rewarded and therefore contribute to sustainability? As we look future of intellectual property in the context of SDG, we must also consider a global perspective. The legal framework that governs IPR are not uniform across the globe. There is a significant variation in how the different countries approach and the relationship between IP and innovation and sustainable development. Thus, international cooperation and policy alignment will be the key focus to fostering the world that must support innovation for the common good. This is why at the University of Mysore, we call for papers that we have invited from you to contribute on the topic of innovative legal frameworks and sustainable development to balance IP rights with the public interest. And we also consider the global perspective to see from the lens of sustainable development goal. It is not only a thorough and open discussion, but it is an open dialogue between all participants and the paper presenters to share their views and to discuss further. So ultimately, our goal is to pave a way for a new paradigm in IP strategies, that one, we can place that SDG and ESG principles to the circular economy at the center to discuss further. So for further discussion, the distinguished speakers, what we have today will shed the light on the various aspects of synergies and drawing from their expertise and research in these two domains. We will now commence with the proceeding of today's inaugural session. First, I would like to invite the organizing secretary, esteemed Professor Dr. Ramesh, Professor of Law at the University of Mysore, to deliver a welcome address. Sir, the floor is yours.
A very good afternoon to each and everybody. Thank you, Syed. It's my privilege to appear virtually before all of you to extend a welcome to all those people who are very eagerly awaiting to present the paper and present their views in this very beautiful webinar on the topic international webinar on legal frameworks for synergizing sustainable development goals and intellectual property. At the outset, I extend a very warm welcome to each and everybody. And we have the presence of Professor Dr. Srinivasulu, Professor of Law, the West Bengal National University of Juridical Science, Kolkata, who is also a proud product of our Department of Studies in Law, Mysore University, and is very actively involved in all these IPR activities, and is also author of many books in this regard across the country. He is well known for his creative thinking for the protection of intellectual property. Not only that, he has been committed to disseminate the knowledge relating to the intellectual property to all the students and all the sections of the society. I, on behalf of the University of Mysore, on behalf of the Chairman, Department of Studies in Law, and on behalf of myself, I extend a very warm welcome to Dr. Professor Srinivasulu on these occasions. Welcome you, sir. And then there is one more student. He was our student and he is also my student. Matthias N. is a senior lecturer, a researcher and a consultant at the Department of Law, Moshi Cooperative University, MOCU, and he did his PhD under the guidance of Professor Dr. Suresh Benjamin about 2 years back. And he is also joining us, and he will be delivering the keynote address on the interplay of IPR and SDG. I, on behalf of all of you, extend a very warm welcome to my student, Matthias N. on these special occasions. There will be, I need to highlight and I extend my warm welcome to Ms. Bharti Shah, who happens to be the IP attorney, Varied Associate, Ahmedabad, who will be joining us in this discussions in this international webinar, and she will be delivering the special address on the topic on the role of IP in sustainable development. Madam, I heartily welcome to this international webinar to you, madam. And our chairman, Dr. M. Suresh Benjamin, who is always there with us to extend all his support to this kind of academic ventures. And he has given the consent to preside over this international webinar, especially on this inaugural functions. He is a man with versatility and known for thought-provoking ideas and everything, and liked by each and every one. I, on behalf of the entire organizations and the University of Mysore, sir, I extend a very warm welcome to you, sir, this international webinars. Thank you. There are many speakers and the resource persons who will be offering their ideas, their opinion on important topics on the sustainable development goals and intellectual property. Here, what we used to learn independently, either of intellectual property or sustainable development goals. But as it was very beautifully explained by Syed, the sustainable development goals cannot be achieved without the support of the proper inventions. In fact, passively, we are also thinking about the intellectual property, which is the backbone of the inventions. So in these connections, many resource persons would like to share their views through their presentations. Let us know what is their opinion. And because we are all actually looking for the best opinion that can be expected from all the resource persons. So, on behalf of the University of Mysore, Chairman, and as an organizing secretary, I extend a very warm welcome to all the resource persons who are presenting their views in this international webinar. And apart from that, there are many enthusiasts who have joined this webinar, international webinar, to virtually witness this webinar in order to gain the knowledge also. For them also, I extend a very warm welcome to this international webinar. Moreover, my student is here. I also extend, her name is Kavya, okay. And she is hoping to cope up with all of us in facilitating this international webinar. I extend a very warm welcome to Kavya also, who happens to be my student. So, on this auspicious occasions, I also extend a very warm welcome to each and everybody, either directly or indirectly helping us. And apart from that, the central person of this international webinar is my student, Syed Krudrat Ashmi. He's a man who is working to conduct this international webinar for more than 1 month, and he has also very eager to learn. Even today, even after passing of LLM from our department, he is pursuing his PhD under the guidance of Dr. Suresh Benjamin. And he is the man who actually behind all kinds of these kinds of activities. I, on behalf of myself and the Department of Studies in Law at the University of Mysore, on behalf of all of you, extend a very warm welcome to my student, Syed Kudrat.
Thank you, sir.
Okay,
You.
now it is over to Syed Kudrat Asmi again. Thank you, one and all. Thank you. I wish you all the best in this regard.
Thank you, Professor Ramesh, for your warm welcome address. It is now my pleasure to invite our chief guest for today's inaugural session, Professor Dr. Srinivasulu, NS, Professor of Law at the West Bengal National University of Juridical Science, Kolkata, to deliver. Professor Srinivasulu is an authority in field of IPR and vast experience in research and policy, and we are privileged to have him for today's program. Before we give the floor to sir, we would like to introduce him, and I would like to request my colleague to brief out the data of Professor, please.
Good afternoon, one and all, who are present here. I, on behalf of Department of Studies in Law, University of Mysore, take this honor and privilege to welcome our guest for the day. Dr. Srinivasulu NS, Professor of Law, the West Bengal National University of Juridical Science, Kolkata, is a chief guest for today's webinar. He is a distinguished member of International Council of Jurists, London. He is a scientific member of Canadian Institute for International Law, Ontario, Canada. He is also associated with World Commission for Human Rights, London. He was a faculty at National Law School of India University, Bangalore, and University of Mysore. In 2007, he was selected as an associate professor. Later, he was promoted as Professor of Law in 2013 at National University of Juridical Science, Kolkata. He is recognized author and he has got his credit over 110 research publications, including 7 books, 3 monograms, 9 edited volumes, 15 book chapters, and 75 research papers published in more than 35 varieties of journals and international publications. Some of his publications are Law Relating to Intellectual Property, which was published in 2018, and Intellectual Property Law, Dynamic Interfaces, 2017, which was published by Butterworth's LexisNexis, London. Law Relating to Biotechnology, which was published by Oxford University Press in 2016, Biotechnology and Patent Law by Manupatra Publications in 2008. He worked with Ministry of Justice, Ministry of Commerce, Ministry of Human Resource Development, Ministry of Transport, Government of India, and UGC for police advice. He has advised for Government of India, West Bengal, Assam, and Goa on legal education, law, and policy issues. He has participated and presented around 25 papers at national and international conferences which were held in India. We wholeheartedly welcome you, sir, for this today's webinar.
Sir, the floor is yours.
Thank you. Thank you, one and all. It's like homecoming to me because as Senior Professor Ramesh sir mentioned, Mysore University is my alma mater. And I got this opportunity because of Mysore University. And whatever I am today, that's purely because of my mother, that is University of Mysore. And many thanks for having me, Professor Suresh Benjamin, who is like my friend, the Dean of the Faculty of Law, Mysore University, and my senior, more than a friend, Senior Professor Ramesh, who is also part of this program. And in fact, the title that you have chosen for today's program, Sustainable Development and Intellectual Property. I personally believe that sustainable development is a very, very broad, vague term, which is having a very, very deeper meaning, connotation, and scope. And in the field of intellectual property, especially, which has got a very wide range of applications in different sectors of science and technology, the sustainable development praise whatever you have chosen has got a lot to say, and it has got its own implications in the contemporary times. As we all know that intellectual property rights law is basically meant for incentivizing, promoting, rewarding innovation and creativity. Now here you are aiming for sustaining innovation and creativity for ensuring development. That's the narrative, right? You are trying to sustain innovation and creativity in the fields of science and technology and as well useful arts for the purpose of development of economy and for the purpose of development of the society at large. How exactly it can be done? Whether the intellectual property regime is all poised to do that. Statistically speaking, if you go with the number of patent filings, number of copyright filings, number of trademark design, or any sector of IP where you are going about having applications to get innovations protected, especially from the side of India. Of course, we have different patent trademark design offices across the country. But when you look at the statistics, how many Indian applications are being filed? How many Indian scientists? How many Indian artisans? They are actually filing applications and they are getting the patent, copyright, design, whatever that government of India is granting. When I started my research on intellectual property rights law, as Professor Ramesh mentioned 20 years back, at that point of time, the Indian filings were less than 2%, right? Assume that your Indian patent office or your Indian trademark office or copyright office is granting 100 patents, copyrights per year. Out of that, hardly 2 applications used to be for and by Indians, right? Now, 2024, if I can give you the statistics, now that percentage has come to 25. So if your patent office is granting you some 100 patents per year, I mean, hypothetically, it's granting thousands of patents per year now. So statistically, if I give you, out of 100 now, your number, I mean, Indian applications, it has come to now 25. So in the past 20 years, we have grown from percentage 2 to 25. So though the growth is, it may not be that seriously considered, but nevertheless, from percentage 2, we have come to 25. Now, with this growth, whatever we are having, we are aiming at a sustainable development. You must be knowing nowadays that people at the realm of affairs talking about the fact that India is the 5th largest economy, and by 2047, when we celebrate 100th Independence Day, we will become 3rd largest economy in the world. All that is happening. All the debates are going. And if you want to ensure that happening, your industry will have to grow. Your economy will have to prosper. And let me say this, that your innovations and creativity are the cream for your economy. And the crux of intellectual property law say that you are promoting trade-related aspects of intellectual property. Those innovations, those creativities which are having trade connection, which are having trade viability, commercial viability, only those things are you are granting patent, copyright, and stuff like that. So it goes without saying that substantial segment of your intellectual property law is basically meant for promoting the cause of economy. So when we are aiming to become 3rd largest economy in the world, this percentage, the statistics that I mentioned, that you happen to grow from second 2% to 25 in the past 20 years, right? And in the coming 23 years, 2047, 100th Independence Day, whatever we are going to celebrate, right? That growth will have to be ensured. We have to ensure that it becomes manifold. From 25%, it has to at least go to the extent of 50%. That means out of 100 patents that Indian Patent Office grants, at least 50 should be belonging to the Indian scientific folks or technocrats. So to ensure that, right, if you open up a number of patent offices in every district or every state, that is not going to happen. Of course, now we have 4 patent offices in 4 metros, all we know. It's not going to happen by opening patent offices in every state. It will happen when you promote the science and technology. It will happen when you go for incentivizing, rewarding more and more innovations and creativity. I happen to submit a dossier, advisory dossier to Ministry of Science and Technology, whereby I said that if you would like to promote science and technology in this country, you have to relax some amount of criteria, technical criteria, whatever you call it as. For instance, in the pharmaceutical sector, we say that only the new innovations, right, new pharmaceutical innovations will be protected, and generic innovations or generic medicine is not going to fetch you any patent. And whereas the Indian pharmaceutical industry is depending completely on generic industry, generic drugs, whatever you call it is. And of course, now you must have also heard about this Janaushadhi Kendras and all that, where government of India is trying to facilitate, provide the medicine at very if not cheap, affordable prices. But reality is that the generic medicine is also produced by the same pharmaceutical companies, the same Novartis, the same Reddy's Laboratory. They're only producing and they're giving you the less quality products. So that is the fact of the matter. That's the ground reality. It's not that your generic industry, generic drug industry is growing. No, the same pharmaceutical companies are producing best products and better products, or affordable products, whatever. And those affordable products are supplied to your Janaushadhi Kendras and things like that. That's the reality, right? So what I proposed with the Ministry of Science and Technology is that you create a separate segment, like you go for protecting Indian traditional knowledge, say Mysore Pak, Mysore Sadi, Dharwad Peda, like that, Banaras Sadi, like that. No, for promoting these things, you happen to come out with a separate legislation, Geographical Indications Protection Act and stuff like that. To promote farmers' cars, you happen to bring about plant variety legislation. To promote traditional knowledge, you are talking about protecting folklore within the copyright. Similarly, right, to promote Indian industry, to promote Indian economy, you need to go about slightly relaxing your criteria. And it doesn't go without you creating this scope wherein you are not going for Indianization of science and technology, but you are going for promoting the cause of India towards promoting innovations and creativity coming from different fields of science and technology. And perhaps now, when we say science and technology, it's not just about biology, physics, and electronics. We have now number of contemporary fields of science and technology, which are physics based and as well biology based. Both are very much required for the cause of promoting your economy. When I say physical or digital based fields of science and technology, I'm talking about information technology, I'm talking about artificial intelligence, I'm talking about space technology, and as well financial technology. When I talk about bio-based technologies or bio-based fields of science and technology, I'm talking about biotechnology, field of medical science, forensic science, and as well nanotechnology. These are the fields which are having greater promise in the contemporary times and which are poised for promoting the cause of the economy. You check out all these 8 fields, whatever I mentioned: information technology, artificial intelligence, space technology, financial technology, call it as fintech, biotechnology, medical science, forensic science, and nanotechnology. Most of the investments in industry are happening in these fields only, right? The major investment is happening, major investments are taking place in these fields only. So if you want to boost your economy, if you want to ensure sustainable development, right, through intellectual property, you need to look at these 8 fields, and which are having greater promise in the contemporary times and which are fetching you most amount of investments, not only from within India, but as well from across the globe, right? Artificial intelligence, it's a big buzzword now, right? Everybody is talking about artificial intelligence, and the people like you and me, especially people from the legal fraternity, they are talking about having a separate law for artificial intelligence, because now it is spanning across from dawn to dusk. There is no sector, no field where your artificial intelligence has no role to play. Similarly, not only artificial intelligence for that matter, I would reckon all the 8 fields that I mentioned are actually hitting you from dawn to dusk. It's not just artificial intelligence, it's space technology. What the medium through which we are meeting now, it is because of space technology, satellite, right? Internet, okay? And the means that we are using every day, Phone Pay, Google Pay, and stuff like that. Financial technology, genetically modified food we are enjoying, biotechnology, modern medical based inventions, modern surgical methods, right? Those things are happening, medical technology, to have identification of ourselves. To detect crimes, we are using narcoanalysis, polygraphy, right? Brain mapping, forensic techniques, and also to hit out at the atomic level, microscopic level. In any field of science and technology, we are working at nano level, nanoparticle level. It's not even microscopic or ultra microscopic, but it is at nano level. So every field, right, we are trying to go for engineering it at a nano level for the betterment of the production, betterment of the yield. And that's the reason why these 8 modern days technologies are having a greater significance in the contemporary times. And most of the investments in these fields. And intellectual property law is, of course, poised to promote innovations and creativity in all these fields. We have seen how information technology field has grown. You started patenting software, you started giving copyright protection to software, right? In the field of space technology, you have seen how satellites are being launched. Sriharikota of Andhra Pradesh, which is close to Chennai, is known to be the second best satellite launcher in the world, only next to John F. Kennedy's Space Center of USA. After USA, India is the only nation which has got the great scope for the promotion of space science, space technology. That's the reason why every day at Sriharikota, our Indian space station, ISRO, whatever we call it as, we are launching number of satellites, not only of Indians, number of European, African, American, Latin American nations are using our space station. So in the field of space, we have grown a lot. We are next only to USA. Similarly, in the field of financial technology, in 2021, Supreme Court of India happened to give a direction to Government of India, saying that you cannot ban cryptocurrency. You cannot ban blockchain technology, right? Why? Because blockchain technology and cryptocurrency has become order of the day. Now, sooner or later, we will forgo the physical exchange of currency. We have already started now, right? We are depending upon internet banking or phone pay, Google Pay, whatever. Sooner or later, right, your 5,000 rupees currency, which is the only currency that you are having now around, that 2,000 rupees currency has also gone. Slowly it will go, because RBI in October last year, 2 months back, announced that it is launching its own digital currency, right? You can understand digital currency, no physical, appearance. So what I'm trying to say, in this field of financial technology also, we are depending a lot. So how the new blockchain technologies can be deployed in controlling cryptocurrency, or in regulating cryptocurrency, or in maintaining your digital currency? These are the modern day innovations which are happening in the field of financial technology. We are also talking about artificial intelligence, saying that everywhere AI, artificial intelligence, is interfering, ranging from agriculture till medicine. Robots are conducting surgery. Robots are going about forecasting the weather, and would suggest the farmers to do what in case of what crop and all, right? All these things are happening, right? Even robots are now working as a car driver. You don't need to have driver. Like people like you and me, no human interference is required. Robot will take care of it. So all these things are happening, right? Human intelligence is slowly getting replaced by artificial intelligence. This AI is imitating you and me, right? Now, instead of you having me, in the days to come, you can go for masking of my image, masking of my language, masking of my body language also, and even you can get the same kind of voice, whatever that that you can have virtually, right? So both Professor Ramesh and Professor Benjamin know my body language, my way of talking and all. So by giving prescription to your AI, you can create artificially Srinivasu NS. You need not have me physically present, right? Right? Those are both of them. They know me from past 20 years, so they know my body language, everything. So you can give input that this body language, this kind of voice modulation, this kind of word framing I want, and that title will be Srinivasu NS. So what I'm trying to say is, artificial intelligence has gone to such an extent now, and the way and means of you creating those innovations, it may be administrative AI or generative AI. When I say generative AI, which it learns on its own, and like we learn every day, going to library or going to attending classes, attending this kind of seminar and fetching the information, going on our own, gathering information. All that is being done by AI on its own. You will create a robot and you will leave it like that, and that robot will start learning on its own, and it will be beyond your control, right? It will become better than you. So these are all the innovations which are taking place in the field of AI, right? So it is actually challenging in a great extent. And it's going to be, and at the same time, there are going to be a big opportunity as well in the same field of your artificial intelligence. So the physics and digital-based fields of science and technology are going to play a vital role in the sustainable development of your future economies. And your bio-based technologies are not falling behind. You take biotechnology, we have seen genetically modified plants, we have seen genetically modified animal, we are having genetically modified meat, genetically modified food, right? In USA and European Union, 2/3 of their farming is happening through genetically based, cropping only. Of course, in India, about 20%. Why they are going for genetically modified or biotechnological engineered, agriculture or other fields? Because it is having better yield. So for improvisation, for adding value, you are going about deploying biotechnology in the agrarian and as well medical field. So there again, you are trying for innovation, creativity. There again, intellectual property law is trying to promote, incentivize, reward the innovation. Your medical field, right? There was a time, say 2 decades or 3 decades back, we used to think that there are certain diseases, ailments which cannot be diagnosed, which cannot be detected, which cannot be cured. Now we have a method by which even hereditary genetic diseases can be cured, right? The hereditary genetic setup structure, whatever we borrow from our parents, and we will pass it on to our next generation, right? We say that this is act of God. We cannot interfere because whatever God or nature has given us, that should be let to continue, and you cannot undo God, you cannot undo nature. No, now it's happening. Through gene therapy, you are able to cure genetic diseases also, right? Hereditary diseases also you are able to cure, right? So to such an extent, the medical profession has gone about. And even the fertile couples are having now babies, right? And even you are extending the longevity of the people also. Organ transplantation is happening. Organ failure used to be a very big problem some couple of decades back. Now you are creating organs also by using the hair, the skin, the blood, or tissues of the individual, right? By using the new and modern methods of medical science, you are able to do that. So all these innovations are now happening in the field of medicine. And coming to your forensic science, as I mentioned, for the purpose of identification and detection, you are using forensic techniques like narco-analysis, polygraphy, brain mapping, and all that. Earlier, only physical evidence used to be there for prosecution. I'm telling you, down the line 10 years, no individual will go to court. No individual will go to police station. Nobody will try to go to police and police station, or courts. Everything will be digitally based, right? No, you don't need physical evidence at all in future. Everything will be based upon digital and forensic. I'll give an example. You must have seen that during Barack Obama's second administration, they happened to kill bin Laden in one hut that he was in Afghanistan, right? And Barack Obama, the then US president, was watching it sitting in his presidential office. How it happened? They happened to catch hold of him through satellites. They figured out where he's hiding, where he's staying through satellite. So satellite has helped them in locating. So that in the similar way, if you are there present in the crime scene, right, satellites can capture you, because all of us are now having a digital identity. Our faces are, have been captured by, our identity cards, our universities, in airports. Our faces are there; they have captured, and through Aadhaar card, retina scanning, all that. Your even biochemistry, your body is also there. So in a crime scene, through satellite, it's possible that who and all were there. Say Professor Ramesh, Professor Benjamin, and myself were there, right? Even we are saying no, I am not there. Our mobile tower will be there, right? Our body will be there, and because of facial recognition technology that we're using now, because of the fact that all our faces are there in the public domain now, right? It is possible even to identify the exact timing of the people who are there in the crime scene without any physical presence or evidence. To such an extent, forensic science, forensic technology is growing, right? And there also intellectual property is trying to incentivize and reward for the further development of for sustainable development. Then coming to the nano, the last field of science and technology that I just mentioned. And this nano, the nomenclature itself says small, tiny, microscopic, ultra microscopic level, you are going about engineering. Nano technology, nano science is spanning across the different fields. It is there in physics, it is there in chemistry, it is there in biology, everywhere. Any field of science for that matter, if you are working at nano level, right? Chemicals at nano level, plants and animals at nano level, it's nanotechnology. Whatever you are trying to engineer at nano level for the enhancement of yield, for the development, right? For boosting its yield, that is called nanotechnology. That is happening at nano level, right? So in the contemporary times, right, we are working at nano level to boost its yield at cellular level, genetic level, atomic level. You are working for the purpose of ensuring that the yield, whatever you are going to get tomorrow at the end of the day, will be sustainable, right? So sustainable development goal is there across the innovations and creativities that are taking place in different fields of science and technology, and intellectual property law is actually trying to facilitate it. Intellectual property law is trying to map it, promote it, right? Ensuring to ensure that these innovations and creativities in different fields are actually meant for or facilitating sustainable development. Intellectual property rights field is poised. And of course, people would have said some 2 decades back that intellectual property is only meant for corporates, investors, and things like that. But today, the fruits of intellectual property are enjoyed by everyone. Every one of us are having now the luxury, convenience, comfort of enjoying intellectual property. I'll give an example. The mobiles that we're having now in our hands, handy. These things would not have been there if 25 years back, if we had not gone for opening up our market economy and allowing foreign investment, or if we had not gone for patent and copyright amendments in later part of 90s, right? Because we promoted, we incentivized innovation. So now we are getting to see. Now, similarly, your genetically modified food, your blockchain technology, your social networking sites, our social networking, whatever we are having, it's the order of the day, right? So number of facilities that we are having now, number of comforts that we are having now, with which we are trying to sustain ourselves and trying to develop ourselves. That is because of the reward, incentivization, facilitation that intellectual property rights field has gone about giving, aiding, right? So therefore, the theme that you have taken for today's program, intellectual property rights law development, is very apt. And in fact, it is indeed the synergy between the fields of science and technology and intellectual property law, which is actually giving way for sustainable development of not only the economy, but one and all. I thank my 2 seniors, Professor Ramesh and Professor Benjamin, for giving this opportunity and calling me back to my motherland. And it's an honor for me to serve my department, my university. Right. Thank you very much. And I would urge Professor Benjamin to go for one physical program before March 2025. You know why I said that. So I would like to meet both of you in my department physically before that, March 31st, 2025. Thank you. Thank you very much.
Thank you, sir. We are truly honored that having you for such thought-provoking and insightful address. Now, we move to the special address. Ms. Datisha is going to address us on the role of intellectual property in sustainable development. Before we go ahead, let's introduce her. I would like to request Ms. Kavya, my colleague, to brief about her.
Our next guest, Ms. Datisha, IPR attorney, Verti Associates, Ahmedabad, will give a special address on role of intellectual property in sustainable development. Datisha is an experienced IPR attorney and founder of Verti Associates in Ahmedabad. This firm is based on specializing in intellectual property. She has a strong academic foundation that includes a bachelor degree in information technology, a law degree, a postgraduate degree in patent law and practice, and LLM in intellectual property rights from Gujarat University. Dati has developed a deep expertise in this field. She is also pursuing her PhD in law from Gujarat University for further enhancing her knowledge. With over 10 years of experience in the IPR field, she has worked across various domains, including patents, trademarks, copyrights, industrial design, integrated circuits, layout designs. Her skill set spans researching databases, drafting applications, managing filing process, and handling the grant stages. Additionally, she has exposure to general litigation practices also. That the extensive experiences and legal expertise led her to establish Verti Associates in 2019, where she has successfully completed her own practice for 5 years. Her combination of technical and legal knowledge, along with her leadership at Verti Associate, positioned her as a valuable asset in IPR field. We welcome you, Manu, for today's webinar. I would also hold our
Am I audible?
Yeah, yeah.
Yes, you're audible.
Yeah. Thank you so much for giving a brief introduction about me. That was so nice of you that you have elaborated in a detail and you have even taken care of my small things, right? You have mentioned everything. Nothing is missing, I would say. Thank you so much. So, as for the today topics, it's all about the sustainable development goals. So, we can consider how the sustainable development goals with intellectual property, what are the challenges and what are the opportunities. I'm going to elaborate on the just to give a little bit idea about it, so we can say what are the policies and what are the challenges that has been covered and which are not covered. So first we will see the aligning IP laws with the sustainable development goals. Countries and international organizations can help foster innovations that supports environment and sustainability, social equality and economic development. So we can explore potential legal frameworks that could synergize SDGs, sustainable development goals, with the intellectual property rights. So everyone knows about intellectual property rights and the sustainable development. So I'm going to just give a little bit idea about it. In 2015, United Nations, they have given us 17 sustainable development goals with the 169 target, which all are interconnected. Many sustainable development goals rely on innovation, technology, and knowledge sharing areas where intellectual property plays a key role, where such as patents, trademark, copyright, and geographical indications are designed to protect and incentivize innovations. However, these laws can also create barriers to the equitable distribution of the benefits of innovations. IP can sometimes restrict access to essential medicine, which can affect Sustainable Development Goal 3 with the good health and well-being. But if we see, even as per the Indian Patent Act, there is a section 84 which introduced the compulsory license. So nobody can take a benefit of the monopoly of the intellectual property rights. When there is a, if you see, there are criteria for getting a compulsory license for even a small generic medicines. Even there is a monopoly, even for the third party distributors or any other person, manufacturers, they can apply before the Indian Patent Office and they can avail and they can manufacture that medicine, the person who has already just a minimum royalty. It is like a for a benefit sharing and just a fair chance for the public who can give or sell affordable price, who can sell in a all over the geographical region and in a with the benefiting just with the minimum royalty. Even if we see the clean technology which can affect sustainable development goal 13, which are about the climate actions which can hindering the progress towards achieving the sustainable development goals. So legal frameworks can, however, we restructure the balance of the need for the innovations with the imperative for broader public benefits, helping to foster the synergies between the IP and sustainable development goals. Now let's check the key legal approaches for synergizing IP and the sustainable development goals. So for the flexible use of IP tools, we can always consider the public interest provisions that I have already mentioned. There is a provision of the compulsory license. If we see the TRIPS, trade related aspect of intellectual property rights, which has been established by the United Nations, and after the World Trade Organization, it has been come into the picture, which is a TRIPS agreement, where all the which allows the compulsory licensing under the specific circumstances, which could enable greater access for the life-saving drugs and the sustainable technologies. There is another key aspect, which is patent pools and the licensing models. Collective IP management models, such as patent pools, which can be helped in a benefit sharing. Open source licensing can be effective in disseminating knowledge and the technology. For example, the medicines patent pools has enabled the broader access to HIV and AIDS treatment in low and middle income countries. Such models promote affordable access to essential technologies while maintaining incentives for the innovations. There is another key aspect, which is the promotion of green IP. You might be aware about the WIPO green IP law, which IP laws can incentivize the development and commercialization for the green technology, for the affordable and the clean energy, which provide the strong protection for innovations to contribute to environment sustainability. This could include patents for the renewable energy technologies, energy efficient process, or waste reduction solutions. So some countries have introduced or could introduce legal mechanisms where IP protections are conditions upon compliance with the environmental standards. For example, if an invention is granted a patent, it could be required to demonstrate a net positive environmental impact or meet a sustainable criteria. So this can be lead to a for the benefit of the sustainable development goals. So even the person who are trying to get the monopoly or exclusive rights for that patent, there is also in the legal framework. So even the normal public, even they can take a benefit of it. So even the third key aspect, if we see, which is a technology transfer and the access. Technology transfer is a vital for achieving the sustainable development goals, particularly in context to industry, innovations, and the infrastructure. With the partnership for the goals, IP licensing agreements, joint ventures, and the collaborations can be encouraged through a legal framework that can benefit to the researchers, developer, or the person who is going to commercialize it, which help and ensures technologies develop in high income countries with to get the low income countries. Another thing, which is a convention on biological diversity and the Nagoya Protocol address the issues of equitable access and the benefit sharing in the case of biological resources and the traditional knowledge which can be adapted to other areas of the technology transfer. So with the sustainable development goal 3 for the good health and well-being, international agreements like Doha Declaration on TRIPS and public health and the access to COVID-19 tools accelerated have highlighted the need to make IP more accessible to ensure that essential medicines and vaccines are available to all, and particularly in the developing nations or underdeveloping nations. So these are the legal reforms, and so by enhancing the collaborations which can create the multi-stakeholder partnership between the government, private sector, and the civil society. This can also include innovation model for the sustainable agriculture, health, and energy, which can cover the sustainable development goal 2 for the zero hunger, goal 7 for the affordable and the clean energy. Countries can integrate the sustainable development goal into their national IP policies, but ensuring that national laws and IP institutions align with the broader global development goals. National IP strategies should focus on how IP can harness to promote the public good, ensure equitable distribution of benefits, and foster inclusive innovations. So now we will see the international legal framework and the IP. So there is a World Intellectual Property Organizations which align or already integrated with the Sustainable Development Goal into strategic plan. and it is actively working on the issues related to access the knowledge, technology transfer, and innovations for the sustainable development. Mainly, WIPO's agenda emphasizes the role of IP on achieving the development goals, particularly in relation to capacity building, technology transfer, and extend to access to essential goods. There is another international framework, which is the TRIPS agreement, trade related aspect of sorry, trade related aspect and intellectual property right. And the third one, which is the international labor organizations and the fair work, which is aligned to the sustainable development goal 8 with the decent work and the economic growth. Now even we see the people who hire the labor or the any person, which are there is a some amount of remuneration which is fixed, even though they are hiring in a lower amount, but there is a still standard, which is the international labor organizations. May require enhancing the protection for workers and creators involved in the innovations process. Legal framework should ensure that IP system recognizes and protects the right of creator, particularly in developing countries where the risk of exploitations can be high. And the last one is a convention on biological diversity, which established the rule for the fair and equitable sharing for the benefits arising from the use of genetic resources and the traditional knowledge. This could be extended to the IP system governing the biotechnological inventions, ensuring that such inventions contribute to both sustainable development and the conservation of the biodiversity, which we can see the every country has a different kind of policy and the rules and regulations for the biological technology. And at the end, we can conclude that there is not a specific legal framework, but there are certain benefits where the synergizing the sustainable development growth and IP need to be flexible, inclusive, and oriented towards the public good. By fostering the collaborations, promoting the access to knowledge, and creating incentive for sustainable innovations, countries can leverage the potential of IP system to advance the global development agenda. Intellectual property law should evolve to reflect the broader social needs of achieving the sustainable development growth, promoting both innovations and equity for all. There should not be like the person can gain the benefit of the monopoly or can take a negative advantage of it. So there is a sustainable development goals. That's how we can reach our goal by 2030. So this is the legal framework which we have covered it. So, does anyone have a question regarding it? I'm sorry. Sir, I'm not able to listen you. It's mute.
Thank you so much, Latisha. Please keep this bonding with us. We would like to invite you further for the intellectual property, and thank you for your special enlightenment. Now we are moving to the conclusion of this inaugural session. I would like to invite esteemed Professor Benjamin, Chairman of the Department of Studies in Law, Dean Faculty of Law, Director of School of Law. It is a lengthy positions to highlight, and Professor of Law at the University of Mysore. Professor Benjamin is an esteemed academician who has authority on the comparative law, and we are also fortunate to have him, and he has guided us through to reach to this point, and we look forward. Sir, the floor is yours.
Thank you, Syed Qudrat Asmi. Good afternoon to you all. Dr. Synergizing NS, a distinguished professor from the West Bengal National University of Judicial Science, Kolkata. My esteemed colleague, Professor Ramesh, the former Dean, Faculty of Law, Chairman, Department of Law, University of Mysore. Dr. Nitesh, the Chairman, Department of Law, Mosi Cooperative University, Tanzania in his absence. Mr. Syed Kudrat Asmi, the coordinator of this program. Miss Dharti Saw, attorney. Varied Associates, Ahmedabad, Gujarat. Miss Kavya, LLM student, and respected participants and friends. As the Dean, Faculty of Law, Chairman, Department of Studies in Law at the University of Mysore, and the President of this significant webinar, it is the privilege and honor to address you today. The present world faces not only political crisis, but also socio-economic problems. You look at the Russia and Ukraine conflict, Israel and Hamas war, Israel and Iran and Syria civil war, Bangladesh and Sri Lanka situations. Beside this, we do find at the domestic and the national level various socio and economic problems. In particular, poverty, hunger, starvation, gender disparity, lack of potable water, regional imbalances, slow economic growth, inadequate infrastructure, inaccessible to quality of education, and unaffordability of healthcare, and so on. All these issues are addressed by the Sustainable Development Goals. You find 17 goals to be achieved by 2030. No doubt, SDGs aim at eliminating poverty, ensuring peace and prosperity, and protection of a planet. The question is it possible? How to achieve these goals? It is not enough to declare the mere goals. What is equally important is to find out the ways and the means to achieve these goals. One of the means to achieve or to realize the Sustainable Development Goals is intellectual property, or in other words, innovation, research and development, competitiveness, and creativity. I believe that intellectual property plays a significant role in ensuring health care and education to all, eliminating gender disparity or inequalities, protecting the planet, increasing the business competitiveness. Ultimately, intellectual property contributes for economic prosperity of the countries and well-being of the people around the world. This seminar provides a unique platform for exchanging ideas, discussing the challenges, proposing the solutions to integrate intellectual property with the Sustainable Development Goals. The legal community, along with the scientists, entrepreneurs, activists, policymakers, has a crucial role in creating and implementing legal framework that advance the SDGs. I extend my sincere gratitude to all the speakers, Professor Srinivasalu NS and Ms. Dorothy, Professor Ramesh, and the panelists, the participants for their valuable contributions to this event. I thank organizers, the faculty of the University of the Law Department of University of Mysore for organizing this the program and for their efforts in making this event a reality. I wish you all a meaningful and productive webinar on this topic, Sustainable Development Goals and IPR. I thank you all.
Thank you, Professor Benjamin, for your inspiring presidential address. With that, we come to the conclusion of inaugural session of this international webinar on legal framework of synergizing sustainable development goals and intellectual property. I would like to once again express our heartfelt gratitude to all of our distinguished speakers and participants who joined us with this series of sessions and we have discussed. So on behalf of organizing committee, Department of Studies in Law, University of Mysore, I thank you all for your participation and attention. Wishing you a productive, enriching discussion and wish you a good day ahead. Thank you.
A very warm good afternoon to everyone. I just want to be clear with respect to, am I audible properly?
Yes, you're audible. Please proceed.
I would also like to have a PPT display. So
Yes,
if,
you can share.
is my PPT visible?
Yes.
All right, all right. So thank you so much for the University of Mysore and the Department of Law for giving me this opportunity. I am Shambhavi, and the topic of my presentation today is Achieving SDG 8 through Geographical Indication, Pathways to Sustainable Economic Growth. So for the very first thing I would like to do is just to understand what is the objective of the presentation here. Is like I'm trying to establish a relationship between the geographical indication and economic growth, and the second part is to deal how that economic growth can pursue SDG 8, which specifically talks about having a sustainable economic growth. So I'll start from the start, that is understanding what is GI. So WIPO and the Section 21E of the GI Act has very well defined the definition of geographical indication, and in simple word, it means that we are trying to match any product or any good with a specific origin which showcases its reputation and qualities. So that is a geographical indication. There are as per the GI Act, Indian GI Act, there are 5 types of goods which can be registered as a geographical indication, which can be in handicrafts, manufactured food items, natural products, and even agricultural products. Few of the examples are Kolhapuri chappal, Mysore agarbatti, Dharwat petha, and the Ambaji white marble, Malabar pepper. However, as we have seen from a couple of times in era, Darjeeling tea and basmati rice are the 2 GIs which has been quite a successful representation of particular origin, and in showcasing the representation of GI in it as well. Now, what is the significance of economic growth? It improves the living condition, increases income, and we also have the opportunity, if we have a great economic growth, that with respect to investment in public goods such as healthcare, education, and infrastructure. Now, what is SDG 8 and why SDG 8? So sustainability is per se a very complex, I would say, and a comprehensive notion. So SDG 8 is something where we have this one thing that to focus on. Also, India being a signatory of United Nations, we can focus on SDG 8, and we must also. However, the GI Act doesn't say anything about sustainability. So it is about time that we understand the significance of sustainability. Now, in order to understand the economic growth, I've tried to make it in three parts in my paper. One is through understanding the pricing. The other is rural development, and the third is to understand from the perspective of overall how public participation can help us attain a sustainable economic growth. So, through the perspective of premium pricing, now what GI does, GI help us to attribute the good from a particular geographical origin, and through that way we can focus on the authenticity and the quality of the product. It also helps the good to be associated with the cultural history. Now, through this way, it is very easy for a registered proprietor to generate employment opportunities, because the direct registered proprietors are the direct producers of the particular good. Also, in a study of Organization for Economic Cooperation and Development, it suggests that the two major influences for economic development is one is market access and the other one is differentiation. So in this part of the slide, I'll try to showcase that how GI creates a significant differentiation in order to attain the economic growth, as the study has suggested that influence with respect to economic development can be assessed through these things. Now, yes, we can focus on market access by having other things like if we market a particular GI in a particular manner. But with respect to differentiation, the moment we register a particular good, it creates a differentiation in itself, like per se, because it has a different set of qualities attributed to it. There is a different set of like, again, genuineness of the product, the superior quality, the exclusiveness, which helps the registered proprietor to command a premium price over that product. So this way, GI creates a differentiation which per se helps the registered proprietor to have an economic growth perspective in it. Also, because the Indian GI Act is there, it also ensures the legal protection of the GI. It fosters a certain amount of confidence among the consumers to ensure that we, not just for 10 years, but like as GI has to be re-registered after 10 years, there is a confidence that my GI will be protected and I will be having a continuous economic like, if with respect to income generation, I would like to say. So there is some sort of sustainability here. Also, Darjeeling tea, basmati rice, these are the examples which has significantly five-folded or doubled the price which has started after the post GI. Darjeeling tea has experienced a five-fold increase in the domestic price. Further, there is Pochampalli saris. Again, after attaining a GI registration, the sale of it has increased. There is a great rise in the pricing. Other than that, because of having a GI, there is a international price has also peaked after attainment of GI, because there's some sort of again, reputation added to it, and economic welfare has also there. Again, now the second thing is I would like to discuss with respect to rural development, how, because GI is targeted directly to the specific origin, we can see that majority of geographical indications are surrounded by the rural areas. So European legislation also stated that fostering rural development will assure higher economic returns to the producers and local actors. Further, I would like to say that increasing economic activity of the other states which are linked to the GI per se will help, like the resorts, the grocery stores will per se get more opportunities to be having more opportunities with respect to employment. The third part is with respect to sustainable economic practices. Now, here I've discussed about the participatory process, how the Amazon, other nations like other organizations like Amazon or Made in India, such practices has to be adopted so that we can in together foster the GI. Odisha, for example, celebrates India's best kept secret. So it is a festival where they come up with various GIs and they try to marketize in a way where an international perspective is gained, and then try to market the product internationally. This also helps to have a proper I would say attention on our GIs. So in these manner I have tried to concluded it. The sustainable economic growth. The last phase of my presentation will be the suggestion: how can we foster economic growth after all this? So this will be like strengthening the legal and institutional framework for GIs. Yes, it is hard. The law perspective could be a little difficult, but we can always think more about the sustainability aspect, because, as I said, GI Act doesn't have any sustainability in criteria under it. Again, connecting GIs to the rural development and tourism program, why the Darjeeling tea has gained so much success and not other GIs. So associating our GIs with the tourism packages, utilizing the world market. We have a lot of trade agreement issues with respect to GIs. EU is not supporting or cooperating. So we can enhance our GIs with respect to that. Again, enhancing awareness. I can say that a lot of people living in their state do not know what are the GIs of their particular state, maybe do not consume the products of their geography. So in general, I will say that raising awareness. Now India has 600 GIs and EU has 3,500 GIs. And EU states to be like 87 billion US dollar GI economy. Now India has 600, which is definitely, I would say, maybe like a very little as compared to EU, but we can at least uh, aspire to have some billion dollar economy as compared to EU, although it is going to be a very tough task, but again, we can always aspire to be. So I would like to conclude my presentation by that. If there are any questions.
Thank you. Tirupati has explored how geographical indication can be leveraged to promote sustainable economic growth under SDG 8, that is design work and economic growth. She has emphasized on the role of GI in preserving local cultures, empowering communities, and stimulating rural economics through the protection of unique and traditional products. Is there any question concerning her presentation? We see none. So thank you, ma'am. We shall proceed with the next.
Thank you so much for giving me the opportunity.
Yes, welcome. You're most welcome. So we shall move with the next presenter, Rajpal from the DP IPR, the same university, Hidayatullah National Law University. The topic which is going to be addressed is.
Hi, I hope good afternoon, everyone. I hope I am audible.
Yes, you are. Yes. Please proceed.
Let me just share my screen. I would like to share the video. Okay. Good afternoon, everyone. I would firstly like to thank the University of Mysore for giving me this opportunity. I hope my PPT is visible.
Yes, it is visible, ma'am. You may proceed, please.
Let me proceed. So, the topic on which I'm going to present today is addressing the adverse environmental impact of fast fashion. And as the Waipur Treaty has been signed recently, I would be looking at it with a reference to the same treaty. One of the major challenges that we face in today's world with respect to sustainability and fashion is fast fashion. So, to understand what is fast fashion, everybody in the market nowadays terms it as a quick entry and a quick exit. So fast fashions are basically rip-offs of famous designers. The fast fashion retailers simply copy designs from famous designers and brands, send them to a local vendor or an overseas vendor usually. So if I am in US and I want to copy a design, I'd copy a US design, send it to China, Bangladesh, or India, where I can find cheap labor, get it copied, get it manufactured, and then sell it at a very cheap price. This gives us the satisfaction of having a branded design at a very, very cheap price. But of course, there are always environmental impacts to this, which I would discuss. So, in the first part of the presentation, I would be discussing that how fast fashion is harmful for the environment. Proceeding further, I'll discuss how we can use intellectual property to combat fast fashion, and at the end, I'll analyze the design law treaty to see if that would help us in combating fast fashion or not. So the key IPRs that are capable of protecting that are capable of protecting fashion designs are copyright, trademark, patents, and designs. But as in India, we have a sui generis design law. That is why the focus would be just on design and the design law treaty. First of all, let us discuss the effects of fast fashion on our environment. As I said, fast fashion is quick entry and quick exit. So when there is quick entry, it means that the manufacture is going on at a very fast speed. That means that 24/7 factories are on manufacturing clothes. This is very harmful for the environment as the factories are running 24/7. 10% of global carbon emissions around the world are because of the fashion industry. This is not only harmful for air, it not only contaminates the air, it also depletes our water supplies, it contaminates the rivers and streams, it contaminates our drinking water. It is very harmful for ocean life, river life, and all the ocean animals surviving there. Apart from this, as fast fashion is quick entry and quick exit, so now quick entry is
Ma'am, we are not audible. Can you hear us? Ma'am, you are not audible. I think there is a technical issue. Ribati, ma'am. Could you help her? So we shall move to the next presenter without taking time. We see if she could join, she can proceed further. Otherwise, we'll go with the next. So we have a next presenter, Ekmas Matlub from Aligarh Muslim University. His title is Traditional Knowledge and SDG 15, Intellectual Property Rights as a Tool for the Biodiversity and Conservation. Sir,
Good afternoon, sir.
Yes, good afternoon. You may proceed, please.
Salam, just give me a moment. I'll share my screen with you.
Yes, please proceed.
Good afternoon, everyone. Thank you for this opportunity. My name is Ikmas Matloob, and my topic is Traditional Knowledge and SDG 15, Intellectual Property Rights as a Tool for Biodiversity Conservation. So I would like to introduce by saying that traditional knowledge comprises of the practices, innovations, customs, traditions of indigenous communities, which play a vital role in biodiversity conservation. These types of experiences and practices are those that are traditionally passed orally from generation to generation in indigenous tribes because of their close connection with the forestry and wildlife. They have a natural affiliation with biodiversity conservation. Sustainable Development Goal 15, number 15, emphasizes on protecting terrestrial ecosystems, aligning with traditional knowledge, with principles to halt biodiversity loss and combat desertification. The relevant provisions of the on biological diversity conservation is Article 8J of the Convention on Biological Diversity. This article calls for respect and preservation of indigenous knowledge and practices. Traditional knowledge fosters biodiversity conservation through sustainable practices such as sacred natural sites, crop rotation, polyculture. They limit the hunting of animals for a certain period or to a certain extent. They follow the practices of crop rotation and polyculture so as to maintain an equilibrium in natural ecosystem. Example of such practices is a sacred forest in Ghana project, biodiversity and cultural heritage. Article 15 of the Convention on Biological Diversity mandates prior informed consent for access to genetic resources. By prior informed consent, it means that the consent has to be free, it has to be prior, and it has to be informed. By informed, it means that the person whose consent is to be obtained has to know the whole of circumstances to which he is giving his consent, as well as he ought to know what the consequences of that consent. There was a case of Divya Pharmacy versus Union of India. In this case, the Uttarakhand High Court upheld benefit sharing obligations under India's Biological Diversity Act 2002. The IPR framework for traditional knowledge includes patents, geographical indications, and sui generis systems to protect traditional knowledge, such as national policy on biodiversity that is being implemented in Brazil, or in Peru. There are laws for protection of traditional knowledge. Also in Philippines, the sui generis system, which provides for rights of
Samatluk, we are not able to hear you.
communal rights. Relevant provisions are India's Biodiversity Act, Section 6, which requires approval before sharing traditional knowledge for research or commercialization. The Nagoya Protocol, which ensures fair benefit sharing from genetic resource use. There was a case of turmeric patent. In this case, the turmeric powder, which is used for its anti-healing properties, especially in the northeastern parts of India, a US company obtained its patent, which was later on appealed by the Council of Scientific and Industrial Research of India. They collected extensive evidence of its traditional use, and thereby this patent was revoked on the basis of recognition of traditional knowledge. Equitable benefit sharing, the conservation of biological diversity along with its Nagoya Protocol ensures for access and benefit sharing for compensation of traditional knowledge contributions. Section 21 of India's Biological Diversity Act mandates sharing of benefit with local communities.
Samatluk, could you precisely tell what are the reading to the text? Could you say that how that SDG and IPR are connected to the present context, with the special reference what you're discussing is traditional knowledge? Because we are running out of time, you may not be able to complete what you have prepared for. Like exactly what is your finding, how you see the nexus between the traditional knowledge and the sustainable development?
Sir, traditional knowledge represents the cumulative wisdom, practices, and beliefs of indigenous communities developed through generations of interactions with the natural environment. So this paper explores the critical role of traditional knowledge in achieving Sustainable Development Goal 15. Sustainable Development Goal 15 emphasizes it focuses on sustainable management uh, of terrestrial ecosystem and biodiversity conservation. TK offers sustainable practices in agriculture, uh, forestry, and medicine, contributing significantly to ecological balance. However, the communal nature of traditional knowledge, it poses a challenge for its integration into the existing IPR framework, which are prominently individualistic. So this study highlights the gap in IPR systems and their implications by including examples of biopiracy.
Mr. Matlab, SDG 15 talks about the biodiversity conservation.
Yes.
You are discussing on the traditional knowledge, how this traditional knowledge has been explored. What are the findings? If you could emphasize on the findings, that we would be glad, and we can have ample of time to discuss. Yes.
Sir, this SDG 15 does not specifically talks about conservation of biodiversity, but it emphasizes focuses on terrestrial ecosystem, which is also part of biodiversity, and by its conservation, it relates to conservation of biodiversity, because there are as I said earlier, the IPR framework is mainly individualistic, because it is for the benefit of individual and for innovation purposes. But this traditional knowledge, because it is a communal thing and because it is collectively enjoyed by indigenous people, so thereby it presents a challenge in the IPR regime. And because interestingly, there are various provisions such as Section 21 of Indian Biological Diversity Act, Nagoya Protocol, which is Article 15, then CBT Article 15. These types of provisions, they provide for protection of indigenous people for access to genetic resources, and for prior informed consent, for mutually agreed terms for benefit sharing. In this way, these things are interconnected, and they complement each other. If I would just mention a few case studies regarding protection of traditional knowledge. For example, in Kani tribe, they collaborated on Arogya Bachya plant, which led to a development of Jeevni drug. There was a collaboration with the company Botanical Gardens and Research Institute. They decided on a 50-50 basis license fee and 2% royalties. This way, we can see that the integration of IPR and traditional knowledge, where benefits are provided to the indigenous population, the actual holders of that knowledge, on which this Arogya Bachya plant led to Jeevni drug. Then the another case is the neem patent, Indian farmers case, in which led to a revocation on patent at the European Patent Office, because this case, because the process of oil production is again based.
Sir, you have exhausted your time. Is there any question with this topic? Mr. Rahman's presentation examined the relationship between traditional knowledge and biodiversity conservation. However, he has emphasized the need for the robust IP production to safeguard indigenous knowledge and practices to contribute sustainable management of the natural resources. Is there any question concerning to his presentation? We see none. Thank you so much for your presentation. So I would like to request back Palak Rajpal to connect back. Her presentation was not doable, so that was due to technical issue. She got disconnected. Ma'am, the floor is yours. Ma'am, Palak Rajpal, ma'am, would you like to present? Am I audible? Yes. I think she could from you, Shambhavi.
Hello.
Yes. Could you assist her? Since you're joining from the same center.
Yeah. Just a second.
Yes, please.
I'm so sorry. There is some network issue here. That is why this is happening. I will share my screen again. I would like to quickly wrap this as there is some issue with the network and I don't want to waste anybody's time. So, as I was saying, the effects of fast fashion, I had completed the effect of fast fashion on climate. Now, I'd like to continue further. To quickly wrap it, the first point was that 10% of global carbon emissions are due to fast fashion industries. The second point is, as most of the material used is synthetic, it is not biodegradable and it cannot be recycled. So this not only causes harm on the soil, it is also very harmful for people who try to grow food around that soil. So it is not just reducing our space to grow crop, but it is also going into our system, because most of the material used is synthetic, which is 50% to 80% plastic. Apart from this, the water consumption of these industries is very high, like 93 billion cubic meters of water each year is used by these industries to make clothes. Now, because we have to fulfill the demands of people, we have to keep the companies and factories running. The water is consumed at a very high rate, and this is usually fresh water. So that is even more harmful. Now, coming to the second part of my presentation, which is why intellectual property is important. So, intellectual property is very important in combating fast fashion, because once you give a design protection through IP, they are not prone to be copied by free riders. So, once the design is protected, it will be harder for these fast fashion retailers to copy the design and then get it manufactured. So, business across the globe invest a huge amount of money in the R&D of designs, because the factor which attracts people while buying fashion is, of course, design. Even our act, the Design Act, says that design, in the definition, it says that design should be appealing to the eyes. So, that is why, as soon as you start protecting your designs with the help of intellectual property rights, it would be harder to copy them. And as it gets harder to copy them, you cannot make fast fashion at that quick rate. So it would not deplete the environment at the rate in which it is depleting right now. um, this is these are few datas which I've collected. So this shows the amount of water which is used by the fashion industry, the first picture. The second picture shows the negative impact, and the third picture shows the impact on soil. So it says that one garbage truck of clothes are burned every second, not even in a day, but every second. So this is a data of US, but of course India is no far, because I couldn't get a correct data of India. So this was just for an example. Now I'd be missing this case highlight, because the case highlight is with respect to the importance of intellectual property right. Rather, I'd go ahead and explain you why the Wiper Yard Design Law Treaty would be efficient in combating fast fashion. Now, the first thing that it would enable is international registration. So, international brands like Dior, LV, etc., are unable to protect their uh, fashion material and designs in other countries. So, as I said, when it comes to fast fashion, you copy the design in one country and you send it for manufacturing in the smaller countries because cheap labor. So, now when you have international registration, the design will not only be protected in one country but in the other country as well. Apart from that, now the WIPO treaty would give you a priority date. So even if your design is out in the market and it's unregistered, for the first 6 months, it will be protected. The third point is that it will be very beneficial for SMEs because there are provisions for capacity building. So when it says capacity building, the act or the treaty says that it will provide people who can come and explain what intellectual property in designs would mean for the developing and underdeveloped countries. Apart from this, one of the very most important thing that is there in the treaty is a provision to deal with exploitation of traditional knowledge. So while filing a application for design, the treaty makes it mandatory for you to put in details of the design that is being printed. So there is a case highlight with respect to the same. So this is a case when Christian Dior copied a design from India and posted it on a magazine. This is a GI tag of block printing from Rajasthan. This was copied by Dior, and then Sonam Kapoor wore it in the Elle magazine cover. So now, if, for example, taking the present situation with DLT, now if Dior goes and wants to register the design, it will have to specify that this design has been taken from a GI tag which belongs to India. Hence, the design registration will not take place. So SMEs and small manufacturers of design will be safeguarded. So these were few points which would help us, understand fast fashion and combat it. I'd like to conclude by saying that fast fashion is degrading our environment at a very rapid rate. Hence, if we have already signed the design law treaty, but as soon as we ratify it, India would be benefiting from it a lot. So once fashion designs start getting protected at a faster rate, it would really be helpful for India in combating the fast fashion. There would be no copied material available. I can't say literally no, but of course the numbers would be reduced because copying would take more tricky methods. You will have to change the design a bit to copy it. You won't be able to copy it exactly. So it would be very beneficial if we ratify the treaty. These are a few suggestions which I felt would be which are some things which the treaty could have. Like the first one is we could have the treaty says that you have to specify the GI. So apart from that, you can see the origin of designs as well. That would also help SMEs. Apart from that, the capacity building program, which there is a provision for that, but it doesn't say anything about public awareness. So SMEs and public, if they are not aware that they can protect their designs, there is no point of having a system of protection. The last point is that, along with having a better registration process, what we could do to attain sustainability is give recognition to green or eco designs. Now, green and eco designs are designs which are made by having a thought of the environment in mind. So when you're designing a product, maybe a cloth, you make it from recycled products.
Thank you, ma'am. You are exhausted with your time. Thank you for your presentation. Is there
Thank
any
you so much.
concerning to this topic? Is there any question from audience? Right. We shall move to the next presenters.
Thank you.
Yes, thank you. Thank you, ma'am. Next presenter is Akshat Aren and Akshana from Reva University. The topic will be discussed on blockchain technology and intellectual property registries, protecting Adivasi's traditional knowledge and biodiversity rights in Nayamgiri Hills. Akshana.
Good afternoon, sir. I'm Akshat Aran, along with my co-author, Akansha Pillai. But in order to have a continuation and flow of thoughts, I would be talking today. So today our topic is blockchain intellectual.
Yeah, sorry for interruption. If you are presenting, so please mind your time that you have to allocate in the way that you could manage your 10 minutes. If you are presenting, it's fine. Then you have 8 minutes and 2 minutes we should have for questions and answers. Yes.
Indeed, sir. So our topic today is blockchain intellectual property registries protecting Adivasi traditional knowledge and biodiversity rights in the Niamgiri Hills. The preservation and protection of indigenous traditional knowledge represents a crucial goal challenge which showcases the nexus of cultural sustainability, intellectual property rights, along with ecological conservation. Our research paper specifically focuses and explores how blockchain technology can be used and it can act as a replacement mechanism for documenting, protecting, and potentially monetizing indigenous ecological knowledge. And we have a specific focus on the Adivasi community of the Niamgiri Hill, which is located in Odisha, India. The Niamgiri Hill represents a compelling case study which is embodying the complex intersection between indigenous communities, their practices, and external development pressures. Indigenous Adivasi communities have historically maintained intricate ecological knowledge systems that represent centuries of sustainable practices, environmental management, and profound biological understanding. However, these communities face persistent challenge of knowledge appropriation, economic marginalization, and cultural erosion. Therefore, it necessitates the innovative approach to intellectual property, protecting their culture and preserving it. The Nyamgiri Hill being a home to the Dongria Kond indigenous community, this region has been the epicenter for intense environmental and cultural preservation struggles, most of them notably in the landmark resistance against extractive mining of bauxite in this particular area by the Vedanta group. Existential threat to their traditional knowledge systems abound, particularly when it comes to biodiversity and ecological management. Biopiracy is also an alarming crisis that has emerged today. Blockchain technology offers a potentially transformative solution to these long-standing challenges as a decentralized, immutable, and transparent digital infrastructure. Blockchain provides unprecedented opportunity for documenting, protecting, and potentially monetizing traditional ecological knowledge. The core attributes of technology cryptographic security. The core attributes of blockchain is cryptographic security and distributed verification, resistance to manipulation, and uniquely align the requirements for comprehensive knowledge protection. Furthermore, in order to promote the protection of tribe, there's an acute need to have an advanced cryptographic algorithm in the same way how we have for the cryptocurrency. We can observe that when the relevant so there are three components in a block. So many blocks together forms a blockchain. So in a block, there are three information that is very important. First is the relevant information that we put in. The second is the hash number. So every block in a blockchain will have a unique hash number, and every block will also have the previous hash number. So there are three layers of security that is present in a blockchain that makes it very difficult and equal to impossible to change the data that is stored and protected in the blockchain. For instance, in a Bitcoin blockchain, there are crores and crores of blocks that are present. And for changing each block, the data in each block and the hash number, it takes nearly 10 minutes. So for changing data and the hash number in every block, it will take nearly 200 years, which is equal to impossible. So that is how blockchain can promote the protection of data of the Adivasi communities. So it protects the endangered information in the best way possible. Traditional knowledge have been classified, and it might be vocal, it might be in the form, it might be documented, or it may not be documented. When we specifically talk about the Dongria Kond tribe, the information of these communities have not been documented. Let it be the plant variety, let it be the traditional jewelry or the clothes that they wear. All these things are not documented from generations. It is a verbal transformation of information from one person to the other in the community. So local communities have to be protected, and furthermore, there's a small project that is launched by Government of India called as Mansa, that is a national level specialized agency which assists the local communities with tourism development, and simultaneously it also promotes natural landscape in particular region, and also it helps in product marketing with the help of blockchain. So the same thing can be done on a larger scale in order to provide to increase tourism and also to protect the indigenous knowledge of these communities. communities. So if we incorporate blockchain in such manner, there are 4 advantages. There's a reduce of wastage of resources, enhances waste management, promotes environmental protection, reduces the risk of using indigenous knowledge in unethical manner. The main problem today the tribal communities are facing is the lack of technical capacity and to protect their indigenous knowledge from being used unethically or from biopiracy. They are unable to protect their products or to share the resources with the people whom they want to share with. And due to this,
Sir, you are exhausted with your time. Could you precisely say that what are the regions in India that they have protected the traditional knowledge through blockchain technology? And what is the exact findings for this? Yeah.
So the Nyamgiri Hill is a very unique place where they have their own traditional jewelry, and there are a lot of plant varieties that are available, that like sweet papayas, pineapples. There are Junu resins that are grown there. So all these plants.
There also, the papayas we get in Mysore as well.
Sir, indeed, we get papayas here as well, but the papayas that are grown there, that the taste of those papayas differ because the soil, each and every facet.
GI law, already we have geographical indication law for that.
We have a geographical indication law, but it is very restrictive, and the advantage of these laws are not able to reach these people because they are not able to protect it, and the people who are coming to them to look to see the people in these areas, they unethically use these crops or even the jewelry for that matter, and they use it in a wrong manner. So the unethical use of the jewelry, the clothes that they grow.
Are you looking for a specific statute to protect only the Nyamgiri Hill, or do you want any comprehensive legislation to protect?
We want to strengthen. Yes, sir. So we want to strengthen we want the Biodiversity Act as well as the GI Act to be strengthened with the help of blockchain technology, so that the knowledge that these communities have, that can be protected in the most appropriate manner, and it will not be misused in the future. There's a shawl that I have to mention. The shawl name is the Kapda Ganda shawl. That is one of the shawls that is stitched by the Adivasi community in the Nyamgiri Hills, the Dongria Kond tribe. This is the only thing that has got a GI tag over there. There are various other things that these people produce, that they make, but that has not got any kind of protection.
You are trying to say that information technology such as blockchain technology to be integrated to GI and biodiversity.
Indeed, sir.
Right.
Indeed.
Thank you. Thank you.
Thank you so much, sir.
Concerning to this? From audience, is there any question? So I believe there's no question. We will move to the next presenter, Mr. Chandrasekhar, Assistant Professor, Galgutias University, and his co-author, Dr. Ankit, from National Law University, again, we are from Raipur. So the topic which has been chosen here is law and human rights, conflicting or complementing each other. So the floor is yours. Yes, you have 10 minutes.
Yeah, so sure. So I just want to share our slides.
Yes, please.
Is it visible, sir?
Still, we don't see you. Try once.
Okay, I'm just trying once.
Yes.
Now, sir, is it visible?
We don't see your presentation, sir.
Okay, sir. I'm just trying once more time. If it is, then otherwise I will start my presentation, sir.
Right. Are you trying with mobile phone?
Yes, sir, because sir, there is a network error in
Okay.
that's why, sir, I am not connecting in our laptop, sir.
Please try.
Sorry, sir, I don't think that it will be
Okay.
easy to
You proceed.
share. So, sir, yeah. So,
Yes.
thank you, sir, for first of all, sir, providing me an opportunity to present about this topic in this prestigious international webinar. So, sir, my topic is patent law and human rights,
Could you
conflicting or complementary.
Could you tell us from where are you presenting your paper? Where is your location right now?
Sir, actually, Galgotia University is located in Greater Noida, that is in Uttar Pradesh, sir. Greater Noida, sir, Delhi.
University.
Delhi. Yes, sir.
It was looking for us like a foreign university, right?
Yeah. It is sir, it is located in Delhi NCR,
Okay,
National
right.
Capital Region. Sir.
Yeah, please proceed.
So as we are having a very less time, so I just want to, I have just prepared the 5 slides to sum up the issues and to sum up the discussion. So first, basically to introduce about that, what is the patent and what is human rights. As we know these things very easy manner, and we know these things very well, that the patents is an intellectual property which is granted with respect to the invention. And invention should be the new, and that invention should have an inventive step as well as the industrial application. Then, by if suppose I have got the patent, then with respect to the patent, I will be given certain kinds of exclusive rights. These exclusive rights are given in the right in personam. So there are 2 kinds of concept, that is right in rem and right in personam. So patents are the right in personam because they are given to the person, and right in them is the human rights concept. So human rights are given to the public at large. So there are certain international conventions as well, which basically have recognized the particular human rights. For example, UDHR, ICCPR, ICESCR. So these are the certain international covenants where the human rights have been recognized. Yes, there are certain other conventions as well. Like if we talk about the discrimination against the women and children, so there are other. But yes, for this particular paper, I have taken these 3 conventions. If we talk about the Constitution of India, so whether there has been any interference of the human rights and IPR or human rights and patent, then first of all I would like to talk about that whether in our Constitution of India there has been any description about the IPR or patent or not. So if we try to find out the constitutional background of the patent law in our Constitution of India, so there are very few circumstances when we can find out the particular circumstances. For example, the union list. Union list in one of the items has provided, that is the entry 47, that particularly provides that yes, union can make law with respect to the innovation, like invention, patent, design. So just except this, there is no other mention in the whole of the Constitution of India regarding the intellectual property protection. But yes, with the due course of time and judicial interpretation, the court has analyzed and the court has interpreted Article 21, that is right to life, Article 19(1)(g), that is particularly right to do the trade, Article 300(a), that is right to property. So the court has basically recognized that yes, intellectual property can be considered as in property like the other physical property. Now, if I talk about the conflicts between the patent and human rights, so I have talked in 2 particular parts. One is with respect to the pharmaceutical sector, and second one is with respect to the patent amendment rules, which have been made recently in 2024. So the pharmaceutical sector, there is a likelihood of assumption, or we can say, because I'm not putting any kind of hypothesis that whether there is a violation or not. So yes, there are certain circumstances where we can basically see that yes, patents are violating the human rights or the fundamental rights in our Constitution of India. For example, the Section 5 of the Patent Act, which basically talked about that like drugs, medicines, foods, with respect to these kinds of inventions, there will be no kind of a product patent. But 2005 Patent Amendment Act has repealed this particular provision. So now we have to give the process patent as well as the product patent upon the medicines, upon the drugs, as well as upon the foods. So the TRIPS amendment, which has taken place since 1999, 2002, 2005, that has also changed a lot with respect to this particular pharmaceutical sector. And yes, before these particular amendments, our generic industry was very strong. Now, after these amendments, only few industries or only few pharmaceutical companies in India are can produce this generic medicine. Yes, today, nowadays, India is having one of the leading position with respect to the generic medicines export market as well. Now, if I talk about the other than Section 5 or other than product patent, so there are certain more provisions as well, which are creating a problem, like Section 3 Clause D, Section 3 Clause E of the Patent Act. But yes, these two provisions are in the Patent Act because of the flexibilities which were provided in the TRIPS. So 3D basically supports the Indian Constitution, like basic idea that the socialism, or in order to protect the fundamental rights, Article 21 of the Constitution of India. Yes, because 3D says that if suppose you have made any kind of a discovery of a known substance, then it will not be granted a patent. The Novartis case is the best example of Section 3 Clause D. Same, there are certain other circumstances like the pre-grant opposition and the post-grant, and one of the most important mechanism in the Patent Act which we are having, that is compulsory licensing. So these are certain circumstances which, according to the pharmaceutical countries, and if we talk about the pharmaceutical lobbies from the developed countries, they are saying that yes, these are the situations where we can find out the patent and human rights conflict, and the patent rights are getting violated. But if we see all the circumstances from a developing country or from the Indian perspectives, yes, we can see that these are the situations from where we can do the flexibilities with respect to the product patent. Now, next I talk about, I have mentioned certain particular cases, but before that, I would like to talk about the patent amendment rules. Yes, sir.
Yes. Sir, you are exhausted with your time. Could you please brief? Yes.
Sure, sir.
You're fine.
So, sir, patent. Yes, sir. So, sir, patent amendment rules, which has been recently published in 2024, they have changed certain kinds of criteria. For example, there are certain good changes has been made. For example, the timeline of the examination has been reduced. But yes, along with that, with respect to the opposition, that has been changed a drastic manner, because now the fee has been imposed. If any person wants to make a opposition, he has to pay the fee. Earlier, there was no fee. Now, the discretion of the controller has also been integrated. Earlier, it was not there. So basically, all these provisions, there has been a change of provisions with respect to the working patents, foreign applications. So all these changes have been made in the recent patent amendment rules. Now, all these are whatever the changes have been made, whether they are in the interest of the trade companies or whether they have been made because India had entered into the FTA with the other countries, or because, see, if we see the data, I have mentioned the data as well, because 22-23 report of the patent that is IP India has published. According to that, only 0.06%, like if you see that 94,000 applications were filed and 420 applications got opposed, which is just as 0.06%. Yes, sir.
Thank you, sir, for exploring often debated intersection of patent law and human rights. As you have discussed both, that they are promoting, and sometimes IP law promotes and sometimes hinders the human rights, particularly with essential medicines and technology, particularly you see in the context of SDG, and we have experienced COVID-19, which India was advocating for the life-saving drugs from the developed countries. So is there any question concerning to this topic? The intersection of patent and human rights. I'm seeking questions from the audience.
Can I ask the question?
Yes, please.
I would like to know the suggestions that would be given from Mr. Chandrasekhar.
Yeah, ma'am, like with respect to the suggestions, like the recent amendments which have been made. So, ma'am, if we talk about the section 84, that is a compulsory licensing. So till now in India, only one case where there has been a circumstances the compulsory license has been granted. So like there are so many cases like the AstraZeneca case where the compulsory license was not granted. So if we talk from the developing countries or from the Indian perspective, so we should support the compulsory licensing provisions more. But recently, when I have attended one of the TWN, that is a Third World Network Summit, so there was a basically arguments from the side that the government is also thinking about that there is no use of the compulsory licensing provisions. So if like suggestions can be like, yes, compulsory licensing can be basically used in order to provide the access to the essential medicines and pre-grant and post-grant. So like we are basically listening to the developed countries more. Like Special 301 report has been released by the US. Now, according to that, we are basically amending our patent laws and we are like creating a problem. Like we are basically creating an obstacle with respect to the pre-grant and the post-grant oppositions. So like earlier there was no such fee, but now we have mentioned the fee. Like what is the problem? When I have also mentioned that there is only 0.06% of the patent oppositions. So like patent opposition can also be encouraged because this is a one way. Like at that time, the NGOs like the Third World Network and other kinds of organizations, they can put a opposition for the like to support the needy people and to support the basically essential medicines access.
Right. Thank you. Now we have Shilamam. Are you satisfied with the recommendation?
Yes, yes, I follow. Thank you.
Yeah, right. So proceed with the next presenters. So tell here, those papers which are presented, those are accepted for us, even in the form of presentation and also publications. These were genuine papers with the findings. So we have some other presenters. Now, I would like to request Serena with the co-author, Dr. L. Maiteli, to present their topic. The title of the presentation is Leveraging Intellectual Property Frameworks to Accelerate Sustainable Innovation in Electrical Vehicle Technology. So the topic is very specific. Serena, are you there? Can you hear us? Once again, Serena, can you hear us? Right. So we will move to the next presenters, Vivek Jain, which discuss on balancing intellectual property rights with the public interest.
Ready? Sunita is ready.
Serena is ready. Please proceed.
Thank you so much.
Yes, please. Mami, since you have a co-author with you, so each one of you have got 5 minutes. So you have to use your time judiciously so that you can save your time and you can present the findings.
Is it visible, sir?
You are visible, but your presentation is not visible. Would you like to share?
Yes, yes.
Please rotate your camera. You have made vertical.
Yes. Good evening, 100 present here. Thank you for the opportunity for presenting
paper. Could you rotate your camera, ma'am? Could you rotate your camera?
Yes. Am I audible?
You are audible, but you need to rotate your camera. Otherwise, you can off.
Tamil Nadu.
Okay, you can off your camera. You can present. Okay.
My topic is sustainable innovation and intellectual property.
Ma'am, could you rotate your camera or switch off your cameras?
Okay, please.
Just switch off and you present. If you can put it. Yeah, now it's fine. Now it's fine.
Yes.
No, again you have shift. Just okay, now it's fine.
Yeah.
Now it's fine. Yeah, please proceed.
Yes.
Yeah, ma'am.
Clear, sir?
Yes. You please proceed.
Okay, my topic is IP strategies vary across different industry sectors due to differences in technology, market dynamics, and competitive landscape. So here are some examples for renewable energy, sustainable agriculture, eco-friendly materials, green building, clean transportation. Property and the sustainable development goals, SDGs. So what are the impacts of intellectual property on sustainable innovation? IP has positive impact on sustainable innovation in different industry sectors. So encourage investment in R&D, then promote brand recognition and reputation, protect confidential information. So these are the impact on sustainable innovation. We know that patenting encourages investment in research and development, particularly in the renewable energy and clean transportation sectors, and promote brand recognition and reputation. We know that trademarks and copyrights promote brand recognition and reputation, particularly in the sustainable agriculture and green building sectors. Protects confidential information. We know that trade secrets protect confidential information, particularly in the eco-friendly material sector. So, best practices for intellectual property management. Here are some best practices for IP management in promoting sustainable innovation. Conduct IP audit, develop an IP strategy, use IP protection mechanism, and collaborate with the IP experts, monitor and enforce IP rights. So, sustainable innovation is a multidisciplinary field that draws on insights from innovation studies, sustainability, science, and IP law. So, sustainable innovation is equal to innovation studies and sustainability science plus IP law. So, this is the ultimate effect of sustainable innovation. Innovation studies plus sustainability science and IP law. So in this study, the methodology uses comparative analysis of 5 industry sectors, especially renewable energy, sustainable agriculture, eco-friendly materials, green buildings, and clean transportation. So data collection from multiple sources, patent data, industrial reports, academic articles, and expert interviews. So result of the study. Co-creation, sustainability, alignment, inclusiveness, flexibility and timing, deliberation, intention, sustainable development goals. So these factors go through the sustainable development goals of a corporate company. So sustainability, alignment, co-creation, inclusiveness, flexibility and timing, and deliberation of intention. So responsible IP strategy, we have to apply these strategies in order to convert a sustainable development strategy. This is the result of this study. Then discussions and the conclusion. Our study provides insight into the relationship between IP and sustainable innovation, we conclude that IP is a critical component sustainable innovation and that its effective management can promote the development and the diffusion of sustainable technologies. So, sustainability and the domain.
What is exactly your findings with this intersection, what you are talking about? Information technology and IPR and sustainable development. Where do you see the nexus between these three domains?
Yes, there are certain recommendations that policy makers develop IP policies that promote sustainable innovation. Then industry leaders.
Is there any policy that passed by the government of India as of now? What are the policies? Which states has implemented? Like where it's reached? Yes.
Yes, patent rights, copyright, these policies are implemented in India in order to promote.
If you talk about copyright, copyright was enacted in 1957. If you talk about the patent, it's also early. So what are the current policies with regard to integration of these three domains? We have a Technology Act 2005, then we have a IPR as umbrella term, then we have Sustainable Development Goal that to be achieved by 2030. Yes, and we have experienced the same COVID-19, which have you see that India has given vaccination to the most of the neighboring states and other states. So what is exactly your finding? Where is the framework that is missing that to be highlighted?
Yes, CSR is implemented to adopt the green revolution in corporate sector. So implementation of IPR through the green revolution is one of the policies implemented currently. So effective IP management is crucial for promoting sustainable revolution. Adopting balanced approach of IP management, we can promote the development of sustainable technology. So in order to introduce revolution.
Right, ma'am. Thank you so much. Thank you so much. You're exhausted with your time. So next presenter, we have Vivek Jain, who is presenting on the balancing intellectual property rights with the public interest. Vivek Jain. Are you there? Can you hear us? So without further delay, we shall move to the next presenter, Jetrin, Anita, and Fatima Hanan. Fatima Hanan, Anita, and Jiten. Am I audible? So, right. Okay, I'm looking for Sumati on driving innovation for sustainable future and connecting intellectual property with SDGs. Sumati, are you present?
Yes.
Please, you proceed.
Can I share my screen?
Yes, you can share your screen and you have 10 minutes.
Whether my screen is visible, sir?
Yes, it is visible, very much visible. Please proceed.
A very good evening to everyone present here, and it's my pleasure to be here. And in today's presentation, I'll be presenting on the topic driving innovation for a sustainable future, connecting intellectual property with sustainable development goals. The main reason for choosing this particular topic is that the interplay between intellectual property and sustainable development goal provides a framework for achieving global issues related to climate change, biodiversity loss, inequality, health crisis, and environmental degradation through innovation and technology to reaffirm the pursuit of sustainable development goals for a better world. And this emerging interrelation between intellectual property and sustainable development can be seen as a double-edged sword because it also gives rise to some legal concepts. In today's presentation, first I will provide a basic outline about the sustainable development goal and its need for, and then I'll dwell into how this intellectual property contributes to specific sustainable development goals and the challenges associated in it. Moving ahead, to know the very basic outline about the sustainable development and need for it. The basic need for sustainable development is the interdependence of human and the environment. And this interdependence provided and made a liability on the human to conserve and preserve the resources and ecosystem for a better world. And the sustainable development is not only about the environmental development, it focuses the interdependence of economic, social, and environmental development, and it also provides a future strategy and adoption for a sustainable future. From the most definition, sustainable development can be seen as achieving the needs of the present without compromising the ability of the future to achieve their basic needs. Keeping all this in mind, United Nations in 2000 came up with eight Millennium Development Goals, which mainly focuses on poverty alleviation, health, education, and environmental sustainability, with the target year of 2050. In line up with Millennium Development Goals, the United Nations in the 2012, through the United Nations Conference on Sustainable Development, have come up with 17 Sustainable Development Goals to achieve the concepts that had already been stated in the Millennium Development Goals, with the target of 169 and specifically focusing on 2030. To move further to measure the impact of intellectual property on achieving sustainable development goals, as we know that intellectual property provides a very basic outline for innovation and sustainable technologies. With regard to goal number 3, which particularly talks about health and well-being, intellectual property, particularly patent, plays a major role in the development of medical tools, technologies, and pharmaceuticals. And these are very helpful for a life-saving a particular person or an individual. And IP also provides certain flexibilities like compulsory licensing, which granted under patent helps everyone to achieve these medical tools and medicines at affordable rate. One such example for that is in 2012, India issued a compulsory license for patented drugs, that is Nexavar, which is used to treat cancer at affordable price. Moving ahead to talk about the knowledge sharing and social equality, which presented under Sustainable Development Goal 4 and 5. Sustainable Development Goal, which particularly talks about inclusive and quality education and lifelong learning opportunities. In order to promote an inclusive and quality education, a copyright laws and an exception under this is like fair use provides an open access to the copyrighted material for teaching and learning process by respecting the rights of the creator. One such example for that is UNESCO's Open Education Resource, which provides free access and the access to the licensed product for using it to teaching, learning, and research process. And patent also provides a major role in promoting goal 4 through the educational technologies that are used in e-learning platform. And more example to state is that, like in India, we have this MOOC, Swayam, and Swayam Prabha. All this provides an opportunity for everyone to get an access to the copyrighted material only for the teaching and learning materials. And through this, IP promotes Goal 7 and also helps to develop social equity by empowering women and promoting the gender equality, which is stated under Goal 5. Moving ahead to know about Sustainable Development Goal 7, which particularly talks about clean energy, clean and modern energy. So in this, IP, like advanced technologies like solar, photovoltaic, wind energy, hydropower system, geothermal, ocean energy, and battery technologies have significantly helped to achieve this goal by reducing the use of fossil fuels, which resulted in the emission of greenhouse gases. And it also enhanced the energy conversion and efficiencies. To name a notable example for that is the Tesla's open patent policy, which provides everyone to use this to promote the sustainable transportation by reducing the use of fossil fuel. So by this, it promotes clean energy, and also it leads to the achievement of sustainable cities by reducing the air pollution and the climate changes which are prevailing mainly in the cities. And then to talk about the role of intellectual property with regard to economic growth and innovation, which mentioned under Sustainable Development Goal 8 and 9. So Sustainable Development Goal 9, which particularly talks about infrastructure, inclusive innovation, and economic development. So IP plays a major role in promoting these goals through the innovation and advanced green technologies. And IP also provides technology transfer and licensing to make these green technologies to be available to the larger audience and to the larger developing countries to achieve their sustainable developments. IP is indispensable from fostering these goals through the innovation and sustainable industrial growth. Moving ahead with the role of IP in environmental sustainability, like IP plays, as I said before, IP plays a major role in climate action through its advanced technologies like which I mentioned before, like solar energy, wind energy, which helps to reduce the use of fossil fuels, and it also, with the help of advanced technologies like renewable energy, carbon capture, and climate resistant technologies, it contributes to achieve goal 13, which particularly talks about climate action. And then IP also.
Sumati, you are interested with your time. So the topic which you have chosen, it is very wide. It is like see, it is what you have chosen. It is like Article 21 of Indian Constitution. It covers all aspects of life. So when we talk about development goal, the reason which we have not chosen your paper for further review, it was that you have chosen very wide aspects of the sustainable development goal. I would like to recommend you that please read the title of Shambhavi Tirupati, which has chosen, see that even the findings while she presented, achieving sustainable development 8, only one topic. Through the geographical indication, just she has highlighted the economic growth. If you see the work and economic growth, if you have been chosen one of that, for example, SDG 13, then you could come with the some findings. As of now, could you tell specifically what are the statistical data, what you have found, like what are the legal framework, what are the legal challenges that government of India, particularly since the presentation is here, like could implement, what are the failures, what is your recommendation?
Like to go with like
you keep highlighting, I don't think so that we reach to the particular findings what we are looking for. So we are looking for a solution. That the solution, like you see, for example, the water purification, what you're presenting now, that is also, it comes out of the challenges. Now that is a solution. So that has been commercialized, and that commercialization created incentives in the form of investment money, right? So something from that, if you could tell us in brief.
Okay, sir. Like in concluding, like as I said, like IP, which helps to attain the sustainability, but it also comes with certain challenges. Like because IP's main objective is to grant exclusive rights, and this by providing exclusive rights, it curtains the ensuring of accessibility and equitable distribution of innovation. Through like that accessibility and equitable distribution is essential to promote sustainability, but that was mainly curtailed by this exclusive rights. So we need a supportive policy and legal framework to align IP rights within sustainability is an essential to promote the concept of sustainability development goals, I think. And then also the principle of mutual supportiveness to bridge the gap between intellectual property and innovation is also essential.
What are the laws? What are the laws which binds these two concepts together in India?
Because like most of the renewable energy technologies are basically from this IP advancement and innovation. So by that way, IP relates to promote sustainability.
Which IP? Are you looking for patent or all the intellectual properties?
With regard to like all of the intellectual property helps to promote sustainability. For example, if we take copyright, that helps to promote education, which is stated under goal number 6 through through this fair use. And if we take a patent, like most of the technologies that used for this education and also for the sustainable agriculture and green agriculture, so that patented also helps to promote.
Right. Thank you. Thank you so much for your presentation and your time. So I'm looking for Amrita. Her topic is guarding the past, the role of intellectual property in protecting traditional knowledge. Amrita, did you join us? I believe she is not there. So Sanjeev. Right. We shall move to Nandini. Nandini P. Right. Next presenter would be Biswas. Am I audible?
Yes. Yes, sir.
Yes. Okay, right. You have the floor. So now you have 10 minutes to present.
Yes, sir.
Yeah, please
Let me
be specific on the legal frameworks and your findings.
let me share for the screen.
Yes, please.
Yes, sir. Is it visible?
Yes, it is visible. Could you move a little so that we could see properly? You're trying with mobile phone, right?
Yes, sir. I'm currently unavailable with the laptop.
Right. Fine.
Can I start?
Yes, you can start. I think you can come to the camera yourself. We don't see your presentation properly. It is fine if you can present.
Unfortunately, my phone's camera is broken and I am unable
Okay,
to
fine.
open.
You can go. You can go without that. Please proceed.
A very late afternoon to the distinguished guests, honorable speakers, and fellow delegates. My name is Rinki Biswas, a student of North Bengal University Department of Law. It's my privilege to present to address my paper entitled "Bridging the Gap: Integrating Intellectual Property Strategies with ESG Criteria to Drive Sustainable Development Goals." So, to begin with, in today's era of growing environmental concern, the integration of intellectual property strategies and ESG criteria is becoming increasingly critical for driving sustainable development. Historically, ESG and IP have been treated as a separate domain. However, there is growing recognition of the need to integrate this framework to tackle the world's most pressing issues, that is, the climate change, inequality, and many more. As business and organizations strive to meet the United Nations Sustainable Development Goals, the demand for innovative solutions that are both economically viable and socially responsible has never been more urgent. Um, with such, business can unlock new value proposition that contribute to economic growth, environmental stewardship, social inclusion, and ethical governance. These four are the main pillars of the SDG for building a sustainable future for everyone everywhere. Now, hence the research objective that I explores is the role of intellectual property in protecting green technologies, and to explore how intellectual property strategies can be effectively integrated with ESG criteria to support the achievement of the United Nations Sustainable Development Goals. As a UN SDG adopted in 2015, provide a global blueprint for addressing pressing issues like poverty, inequality, climate change, and peace. The research will analyze how IP can contribute directly to achieving these goals. Now, the vital need for protecting the green technology in advancing the sustainability is from renewable energy solution to eco-friendly innovation in transportation and other sectors. Green technology represent the most promising opportunities to reduce environmental harm and pave the way for a more sustainable future for generations to come. Protecting green technologies through intellectual property is essential for driving global sustainability effort, because the IP safeguards innovations like renewable energy system, efficient energy product, and sustainable materials, ensuring that inventors are rewarded for their eco-friendly inventions or solutions. By securing patent, eco product, trademark, copyright, industrial designs, and plant variety rights to protect development in green technology, IB foster healthy competition, encourages collaboration, and accelerate the commercialization of these technologies, making them more accessible in the market. Uh, And so now let us understand what is the ESG criteria is. ESG basically stands for the environment, social and the governance. The E in the ESG means the environmental. Environmental factor pertains to the impact that an organization has on the environment as well as its approach to risk management. This encompasses both direct and the indirect greenhouse gas emissions, the management of natural resources, and the organization's resilience to physical climate risks, such as the climate change, flooding, and the fires. It also includes an effort to reduce the company's carbon footprint with an emphasis on sustainability and minimizing environmental harm. And the social pillars of ESG focus on how companies can manage relationship with other employees, suppliers, customers, or the communities, addressing the key issues such as the diversity, inclusion, labor right, and the consumer protection. It emphasizes an organization's interactions with its stakeholders and includes metrics like the human capital management, which covers fair wages and employee engagement, as well as the company's impact on local communities. And finally, the governance pillar of ESG pertains to how a company govern itself, encompassing its leadership structure, ethical practices, compliance, transparency, and the corporate accountability. So, some of the key ESG framework that I have included is the Global Reporting Initiative (GRI), which is an international, independent, and non-profit entity. These standards are a widely used framework for sustainability reporting, allowing companies to disclose their ESG impact. Second one is SASB, that is Sustainability Accounting Standard Board, which provide industry-specific guidelines for disclosing financially material ESG factors relevant to investors. Uh, Third one is Task Force on Climate-related Financial Disclosure, which has been created in 2015.
Biswas, could you tell specifically on the legal framework of this topic what you are talking about, rather than reading it or you're giving information?
Sir, it basically talks about the link that is existed between the IP and the SDGs, aligning with the ESG criteria.
Yes, we talk about the ESG, that ESG is a principle where it controls the business behavior of the companies, that the invention should be economically profitable, also it should be socially responsible, and environmentally sustainable. Even the business strategies should be adopted in that way to attract more investment. So what are the exact provision of the law that governs? What is your highlights and findings? See, we are looking for solution and findings. We're not, yes.
So first one is IPR is directly linked to the SDG 9, that is in innovation, industry, and infrastructure, by promoting innovation in industrial sectors, by safeguarding the patent, trademark, and the design.
This was if we talk in the terms of interaction. See, IPR is like umbrella term. SDGs also. Each component of IPR can be connected to each component of the SDG. It is not only to the 9. Even to 1. When you talk about poverty, what SDG 1 talks about? It talks about poverty. The second one, it talks about zero hunger. So what patent law protects? Patent protects innovation. So when you talk about poverty, what IPR protects? Innovation, incentive for the invention, for the creative work, literary work. So there is a means economic benefit, right? For the author of the work, for the creator of the work. So there is economic growth. IPR can be connected to all these SDG goals. Could you tell specifically, for example, when you see the 16 or 17, it talks about the strong institution and justice. So if you have a strong IPR, then there will be rule of law. Then you can appear substantially and even procedure-wise. So could you tell specifically what are the provision of the law that governs which you are presenting right now?
So I haven't.
What are the gaps? The gaps you are trying to bridge?
So there are the many challenges that the organization policy.
You are trying to tell that there is a challenges, because of the challenges cannot be connected.
Yes, sir.
What are the challenges? Could you tell?
Because of high
Yes.
Because of the high patent cost, limited access to technology, and the lack of the local IP infrastructure, it may prevent developing countries from accessing crucial innovations. For instance, patent on the life-saving drugs, vaccine, or the clean energy technologies may be too expensive for the population that need them the most, hindering progress on SDG, that is the SDG 3, good health and the well-being, and SDG 7, affordable and the clean energy. There are other challenges. Should I highlight?
Thank you, ma'am. You are exhausted with your time. That's what we were looking for. Thank you. So next present we have Shrimati Sheila Ganesh, ma'am.
Yes.
Yes. Would you like to share your PowerPoint presentation, or would you like on the camera?
Very presentation only, no sharing of people. Good afternoon, I'm Sheila Ganesh, Assistant Professor, JSS Law College.
Ma'am,
And
could you turn on the camera? We would like to see you.
yeah, I'm already turned on my video. It's
No,
on or
we can't see you.
now?
We don't see you. Let's help you technically. Yes. Yes, ma'am. Yes.
Yes. Good afternoon, I'm Sheila Ganesh, Assistant Professor, JSS Law College. Today's topic is, I have opted for this topic, conflicting dimensions of intellectual property rights, sustainable development goals, and access to medicine equity. And before I begin, I would like to thank Department of Studies in Law as well as University of Mysore for giving this opportunity, and also the organizing team committee who has arranged this international webinar on legal framework for synergizing sustainable development goals in intellectual property. So I'll be taking my study first relating to public health, and followed by certain aspects like the sustainable development goals and the constitutional provisions, international efforts in attaining the sustainable development goals as far as access to medicine is concerned. Then followed by checking upon the provisions under the patents law regime as well as the Drugs and Cosmetics Act of 1940. And what actually is the real problem with regard to patents? We are not blaming completely about the patents. What actual problem, the growing challenges are there? Such concepts like evergreening of commodities, pharmaceutical products, or we can also say blockbuster drugs. These are making the things, medicines not non-affordable, or maybe it is not having access to it becomes more critical. So we try to refer to the TRIPS agreement as well as WTO regime. And we also see the following events. In 2001, we had Doha Declaration and Cancun Declaration in 2003, like that. And we also refer how far it is feasible. And there are some ways of not just limiting only to compulsory licensing. What are the means in which we can try to attain access to medicine, balancing both intellectual property rights as well as the areas of public health. So the health, we all know the health is a fundamental right, and it's been declared in our constitution as well as in the World Global Assemblies and other conventions as well. However, having said so, we have not attained complete right to health. So we have attained only to the marginal extent only. So how to carry forward this? It's only we try to relate the more responsibility is shouldered on the government in bringing about necessary policies, programs, and as well as legislative measures. And first of all, public health, when you say it's a complex phenomenon, and it wants to have a holistic idea about how to attend to the address to the area of public health. And we refer this maxim called solus populi suprema lex, people's welfare is supreme law. Here again, it applies for public health aspect as well. When we are speaking about public health, we refer to the value of given to public health, that is equity. Everyone must have the access and also the affordability of having the public healthcare facilities. And we have to follow the global influences as well, as and when the trends of global influences are there. That's why we are taking this sustainable development goals also a topic, when this is one of the global initiations, and global health is also to be considered in this light. And when you say public health, relating to the global health perspective also, we must make necessary provision for making clinical facilities, including healthcare, drugs, and medicines. And for my research, I would like to taper it down to access to medicine. When you speak of public health, it may be very comprehensive, and maybe we'll be running out of the time. And WHO now it refers what is public health or health in general. It's a state of complete physical, mental, and social well-being, and not merely absence of just free from diseases or infirmity. And as far as WHO is concerned, the health, according to WHO, it tries to refer to resource of living, not just mere animal existence, a resource of living. And why we have to speak about health? Because people are born with a certain type of disease and death, everything. These are all natural course of events. But how well we can actually bring more effective lifestyle, better the quality of living, and that's where you see the need for medicines is also be counted. And we have different types of disease, health problems in the name of disease. So it could be congenital disease or acquired diseases, or it could be the form of communicable disease or the non-communicable disease. Wherever we see there is a need for medicines. So there is now that's how we take forward the public health. And there are also definitions given by Winslow as well as Beagle and Bonita. They have given a comprehensive definition. Now that there is a crucial role of the government to bring about in protecting and promoting the public health, and that has also I have referred in my study. And I also traced the Indian concept of public health and how it has to ensure and what type of necessary policy measures, programs, and other legislative initiation has to be brought by the government. That has also been discussed. Now, the status of health, the public health, is that we have given the human right-based approach. Whenever we say that's a human rights-based approach, there comes, it's not only the individual's claim for their right, but it is also a bounden duty of the government to bring about to make situation where it is feasible for the people to realize the right to health. So that's where again we count for the need for the government's obligation in this regard. As far as the global arena is concerned, the global efforts are concerned, we trace the efforts of World Health Assembly, and which had come forward with an idea of health for all by the year 2000. So it could not, that means these are all promoting things where we try to achieve one by one in the course of events. So though may not be completely successful, but still we have the hope and promoting the healthcare. And that's why we had a Millennium Development Goals and followed by and the Sustainable Development Goals. So all these things aim in ensuring the fundamental principle being that to ensure equitable distribution of health resources in every nation and as well as globally. And followed by Almaty Conference in 1978, that is also insisting to build strategies and plan of actions to launch sustain public, primary healthcare as part of the national health system. And following which, India has also brought about various national health policies in the country and addressing various health-related issues. Now, moving forward with the Sustainable Development Goals, I would like to make a specific reference to Sustainable Development Goal number 3, so which deals with the good health and well-being. And in order to achieve this, so there are further 13 targets been identified to achieve this particular Sustainable Development Goal 3. And among the 13 targets, I would like to refer to 3 important targets. That is how to fight communicable disease. So there are various types of epidemics prevailing throughout the world, like AIDS, tuberculosis, malaria, and neglected tropical diseases are there. So the medical facilities and the goal also aims to address this the communicable disease, to eradicate or completely to put an end to epidemics as such. That was the target. And another target to achieve universal health coverage, that is also been mentioned in one of the target. So which includes the financial access to quality essential healthcare, as well as affordable essential medicines, vaccines for all, and so on. And one more target that has been stipulated there is support research, development, and universal access to affordable vaccines and medicines. So especially this aims to help the developing nations and to bring about the medicines at affordable cost, including the essential medicine and vaccines. And it also tries to want to keep in accordance with the Doha Declaration of the TRIPS Agreement, which helps developing countries in various aspects. And just like that, it wants to promote public health and also to make available the access to medicine for all. And that's what the Global Forum, that is SDGs, try to aim in essentially bringing about good health for all people throughout the world. Apart from SDGs, there are other international guidelines, UDHR, ICE, SCR, ALMA-ATAR, CEDA, CRC, IHR, that is International Health Regulation, UNCRPD, like that, many other efforts are there. And now relating to constitutional provisions in India, it's needless to say the preamble of the constitution itself speaks about welfare state and the social justice. All this idea it tries to achieve egalitarian society, and this is being carried forward in the fundamental rights, though the fundamental rights does not specifically speak about right to health, but invariably the courts have interpreted it in a length, and they have accommodated right to health within the ambit of Article 21. And more important to this fundamental rights, the directive principles of state policy plays very crucial role in ensuring healthcare, especially Article 33, 38, 39, 41, 42, 47, and 48A. And I would like to reiterate that Article 33 it's been ignored in many of the aspects. That means it speaks about duty of the state to apply directive principles of state policy in the making the law. So it is so progressive, it is so proactive. It gives all scope for the government to bring about the legislation in to meet the needs of the directive principles of state policy. That is the welfare state idea. And now just we are coming to the core area of pharmaceutical patents. So why, first of all, let us understand what is this pharmaceutical patents and why it is required and how it is carried forward and what are the types in it and what is the actual problem in addressing, specific to that access to medicine. So every drug, it's like any patent, and again, I'm relating only to patent laws of intellectual property rights and not covering other aspects with regard to pharmaceutical products. So the pharmaceutical products could, unlike any other innovation, it requires more serious process, and it's not every type of drug what they identify or innovate is going to be success. So out of all million, and they are going to break it down and 5 active the API compounds would be identified. It would be followed by medical research and clinical research, and finally testing their efficacy and safety. It's going to come to the market. So a lot of investment is required, a lot of cost is required in it, and also the other infrastructure and regulatory compliances are there. So it is pertinent to provide them with adequate recognition in the form of patent law that is being well recognized. That is a valid kind of contention. Every pharmaceutical company also will place it. And what is how long is the duration of pharmaceutical patent given? Its duration has been now stipulated to 20 years of time. And on what basis the pharmaceutical patents are given? It's given on the basis of 3 requirements of innovative step, novelty, innovative step, industrial application. Unlike other patents, it is trying to make it more stringent and technical for application of patent. And what types of patents are available as far as pharmaceutical patents are concerned? There are 3 major types, like product patent, that's the recent one, the product patent. Initially, it was granted with process patent, and also even to the formulation patent, it is being identified.
Thank you, ma'am. You are exhausted your time. Could you briefly demarcate between the patent process and patent product in India? Like what are the legal framework right now? What are the challenges between the two?
Patents Act of 1970.
Yes, why Indian steps are different with the US in case of the patent products and patent process?
Yeah, in US, since you have asked about US, in US we have Hatchman-Waxman and legislation that's called Drug Price Competition and Patent Term Restoration Act of 1984. It somehow tries to balance between the generic manufacturer and patented drugs. My area of concern is with regard to how well the patented commodities could come very, very soon to the market at affordable cost. So there is a practice by the pharmaceutical companies, what they try to use, they manipulate or misuse the patent term, and they would like to extend the patent term, not just limiting only to 20 years. They would like to make slight modification and extend to the term such that idea is called as evergreening. And not only that, they have come out with the idea of called the blockbuster drugs. The blockbuster drugs, though it is maybe all type of drug, even the certain drugs which is of common nature, like the diabetic drugs, BP and other tablets, cholesterol related drugs. So what they try to do, they want to hit the market always. That's called something called patent cliff. So they want to ensure that their commodities, given the period of time, they would like to have maximum profit out of it. So that's the patent cliff or the blockbuster drugs. And now the crucial thing which we have to note for the sustainable development goals is that we must limit this blockbuster drug kind of culture, or we must stop extending of patent regime, duration, evergreening of patent. What the drug companies, what they do, they try slightly bring some modification by the end of the patent term. They try to bring slight modification and try to make it as a new drug. And India in 2005, we have brought an amendment to the patent regime. We have brought section 3 clause D of the patent regime, which speaks about how we can bring about the significantly enhanced effectiveness. So that's what we see in the Novartis case as well, and we could not win in India. We cannot patent. They cannot obtain a patent in India, and that's the thing. So in my study, I have come out with these type of suggestions to encourage more voluntary licensing from the manufacturer. There is a role even to be played by the pharmaceutical companies. They should come forward, not just sticking on to the patent regime or the terms or evergreening practices. They must come voluntarily to license their rights to others, so that others can come with more generic medicines. And also, with compulsory licenses, we have to increase in the country as and when the need. So waiver protection.
Okay, thank you. Thank you. Srimati Sheila Ganesh has explored for that. She's advocating for affordable medicine and access to medicine, which is aligned with the sustainable development goal to be achieved by each state. I mean, I'm talking about the countries. So we shall move with the questions, if there is any question from the audience. We are looking for questions with regard to patent, affordable medicine, access to medicine. Right. Thank you, ma'am. Thank you so much. There's no question for you. So we shall go for the next presenter, Laskar. Mochin Laskar, are you there? So, right. I'm looking for Suma. Suma, did you join? With the title Traditional Knowledge, Intellectual Property and Sustainable Practices in Indigenous Communities. Right. I believe she didn't join. Miss Sunita, along with Renjin. What is there in the chat box? Does she message that she's here?
No. Someone else.
Okay, it's the question. Right. So among the presenters, I see some presenters who are absent. Sunita, Suma, Laskar, 3. So I will just see if any of these absent. Vivek Jain, did you join? Sanjeev. Right. I think we come to the end of the program. Now we shall have, yes.
Am I audible, sir? Myself, Jyoti Meenakshi. I'm also one of the member of presentation.
Okay, please proceed.
Is it visible, sir?
Yes.
Can I present?
10 minutes, if your time. Please use your time judiciously and tell us directly what are your findings, what are the legal challenges that you would highlight and bridge for the discussion. Yes.
Is the screen visible, sir?
Yes, you are visible, but your screen is not visible.
Okay, fine, sir. Okay, so my topic here is the impact of geographical indications on sustainable rural development, comprehensive economic and cultural insights from Wayanad. So it is a particular study on Wayanad. So it is common that GI is a form of IPR that identifies a product as originating from a specific geographical area where its quality, reputation, and other features or characteristics are intrinsically linked to its origin. So many GI products are produced using eco-friendly practices passed through generations, and it is quite common in Wayanad also. It often certifies the authenticity of products, discouraging counterfeit goods. So the recognition of GI has a profound impact on the sustainable rural development, and it protects the products originating from a specific region with unique qualities linked to its geography, and that is also quite common in Wayanad. GI particularly contribute to multiple SDG, which includes SDG 1, no poverty, SDG 8, and SDG 12 also. And with regard to the policy taken by the government regarding GI, we have GI of Goods Registration and Protection Act 1999, which helps for the registration and for e-commerce platform. Which includes Tried India Initiative Awareness Mission, and we have One District, One Product Initiative. So these action and its ease of registration. But the research gap in my particular study is that even we have these kind of policies in India, but some sort of what you say, some sort of discouragement is also facing from Wayanad as the there are lots of local producers. They are literally not at all aware of these kind of infrastructure facilities. So these kind of challenges are literally seen in Wayanad, and that are one of the complications that faced in this particular area. So this particular study aims to evaluate the economic impact of GI on local products in Wayanad and to analyze the role of GI in cultural preservation and environmental sustainability to identify various challenges and opportunities through GI implementation and to also propose various policy recommendations for lasting rural development. And it is found through the study there are mainly high cost and complexity of registration, limited awareness among the local producers, inadequate infrastructure, difficulty in accessing broader markets. So these are the various challenges that I found through the study. But still, there are opportunities also as part of the SWOT analysis. And we found that boosted market value is there in particular region, cultural heritage preservation is there, promotion of sustainable practices, enhanced rural tourism. These are all quite common in Wayanad considered as an opportunity. When coming to economic and social impact, when coming to economic impact, GI increases market value, created jobs, stimulated rural economic growth in general, and also as a cultural perspective, GIs safeguard traditional knowledge and reinforce cultural identity. And on environmental perspective, it promotes eco-friendly production methods and biodiversity conversion. And also, I took mainly 5 case studies: Aranmula Karnadi, Wayanad Jeeragashala rice, Malabar pepper. So these are the various GI products which is quite familiar in Wayanad district. And it is found that the main challenge faced by these products are by the local producer are like they are not at all able to get a broader market. They are not all getting enough infrastructure. So the policy recommendation from my side or from my project is that financial support for GI registration and its marketing, awareness campaigns to educate producer distribution, collaborative efforts between stakeholders, simplification of registration process, and this will all help for the local producers to just go through this GI products and their protection. And on a concluding note, I can say that geographical indication drives sustainable rural development by enhancing economic, cultural, environmental aspects. So while we are addressing these challenges and leveraging opportunities, will literally maximize the impact on regions like Wayanad and other these local areas. So this is what I found through my studies.
Right, thank you. So we have a next presenter, Laskar, Mochin Laskar. Till she joins, is there any question from audience to her? Yes, Laskar, you may proceed, please. Would you like to share your presentation? Mochin Laskar? Is there any question to the previous presentation? Okay, right. She has a network issue. Right. Is there any other presenters? Some were absent. I will recall once again. Sanjeev, Amrita, Nandini, Jatin has joined. Right. We come to the conclusion of the program. We shall have a brief vote of thanks, then we let you know. To go. So, right, we come to the end of the program. I shall render a vote of thanks to all of you, dear esteemed guests, speakers, presenters, and participants. We extend our heartfelt gratitude to each and every one of you for making this program success. this was not the work of the organizing team alone, but it was your contribution that you have joined us and you made it happen. And when I use we, I'm talking on behalf of my organizing committee at the Department of Studies in Law, University of Mysore. And I would like to especially express my heartfelt gratitude to Honorable Vice Chancellor, University of Mysore, who has given us permission, and the Honorable Registrar, who has helped us with all the formalities, such as giving this room where we're sitting and communicating with you, and give us permission to post and conduct this program. To our distinguished guest speaker, Professor Srinivasulu Ines, who has given his precious time and highlighted with this topic thoroughly, and we are enriched with his explanation and insightful discussion. Of course, a young IPR attorney, Dati Shaw, who has given a broad perspective of IPR and SDG, and Professor Ramesh, organizing secretary to this program, and Professor of Law at the Department of Studies in Law, University of Mysore, who has guided us thoroughly from the beginning till today to this program to happen. And including to Professor Ramesh, we have Professor M.S. Benjamin, and who is the chairman of the Department of Studies in Law, who has given us permission and communicated with the University of Mysore and encouraged us and supported us to conduct this international webinar on legal framework and synergizing IPR and sustainable development to harmonize these two domains of the law. And in his absence, I would like to express my gratitude to Professor Maruti, who has supported us during this program. I should not forget to highlight the role of this institute. It is called Institute of Excellence at the University of Mysore, who has provided this hall and gave us permission that we conduct here, and the director of ICD at the Computer Science Department, and Mr. Milan, who has sit here for long hours and supported us. And thank you to all of you that you have joined from the different parts of India and you have given your time. Your thought-provoking presentation and your engaging with the discussion has enriched us, and we now understand the complexity of Sustainable Development Goal and IPR. And we are looking now to create more sustainable and equitable future. So we also appreciate all our teams who have helped us in her absence, Kavya, and all of you that you have joined us, and the participants who has been this long time with us. So thank you so much. Thank you so much that you have joined us, and we shall maintain this bonding, and we will continue. And I would like to see you in next webinar, which we have on 14 December 2024. And we have a professor from Belgium, and we have a professor from Jindal Global University, who is going to talk on the intricacies of international investment law and IPR. I hope that to see you again. Thank you. Thank you so much. So close the recording.